All right. Good morning, Ms. Strong or Mr. McLean. How are you?
Very good, Your Honor. Good morning.
Morning. How are we proceeding today? Everyone's back there?
We do have everybody here.
Okay, excellent. Good morning, ladies and gentlemen. My name is Judge Lal, and we are going to commence with our state all-purpose calendar. This is a list of misdemeanor cases in which individuals have been arrested and accused of certain misdemeanor offenses. Their cases have been formally accused, bonds have been set, initial appearances have been completed, and today we're going to get a snapshot or a status of how the individual would like to proceed with the case. Certain cases may move forward with what we call a plea hearing, in which the defendant has agreed to accept the recommendation of the prosecution in exchange for a guilty or no contest plea. Certain other cases will be entering a not guilty plea, and the cases will move forward for trial. Other matters we may address are bond modifications, probation revocations, as well as motions to set aside bench warrants. If you're a defendant accused of one or more offense, please remember that you have a right to remain silent. Anything you choose to say in open court, even if it's virtual court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Okay, Mr. McLean, have you spoken with everyone that you need to interview?
Your Honor, I'm waiting for a phone call from a social worker, but the person I have not spoken to yet is Jalen Riddle, who was in Central Holding at the time. He's gone? So never mind about Jalen Riddle.
All
So
right, he's
yeah.
released?
Yes.
He's been released, they tell me.
Okay,
That leaves Floyd Irving, number 1819. The state was going to tell us whether that case was already pled out or not. And
okay.
I checked my email this morning. I checked it last night.
And was that Miss Vigilante back? Oh, that Miss Abden. I think that was Miss Abden.
He's here and Miss Vigilante is here.
Okay. Good morning. All right, let's then proceed with the first case that's ready.
Yeah.
We've got several. You want to go down? You want to just go numerically, or you want to?
We could go to, do you have Criswell,
Criswell?
or is that Miss Vigilante?
That's Miss Vigilante. Your Honor, why don't I go ahead and announce? I believe the announcement's already in on 20 and 21.
Oh, just 1 minute, please. I have your announcements. Is there anything different from what you've got?
No, that's a waiver of presence and arraignment. We'll file that with the court.
Okay, let me get to that then. So
So go-
petition 20 and 21, you're filing a waiver of arraignment, and that's
Right.
going to be further notice for trial, okay?
Just going down the list numerically from that point, Quinetta Jones at ACDC is ready.
Okay,
Mario Keen will be ready because
Right here. Yes, it does.
okay. I haven't heard on the counter offer, but it's a simple counter offer and could easily be told, switched to being called a non-negotiated plea. He simply asked that the jail part of his sentence be time served instead of extra time. As to the probation part of the sentence.
okay, so there's a question about the counter. Okay, what about, so let's begin with the gentleman seated next to you. What's his name?
Mario Keen, number 23.
Okay, and Mario Keen is going to be, Mr. Pierre Thomas, do you have a response to the counter made by the defense?
Your Honor, the counteroffer will be addressed by Deputy Chief Falk in just a second.
Okay, she's not, she's on her way, okay, and we'll just
Yes.
hold on Mr. Keen until Ms. Falk appears. What's the announcement on the positions 25 onwards, Charlisa Curry and onwards?
Right, well, 24 onwards, Mario Lewis would be a negotiated plea. He's right
Okay.
after Mr. Keen.
All right,
There are two Marios there and it can be confusing. They are different people.
I got them lined up, so I'm okay.
Okay, so 24 Mario Lewis is a negotiated plea. Charlicia Lurie, number 25, is a non-negotiated plea.
Mhm.
McGee is being reset 2 days. We have no objection to the 2-day reset being proposed by the state. Next is Gillette Pulliam, number 28 at ACDC. She told me she was represented by Maureen McLeod in another case. And
Okay.
although one of our attorneys was listed as having been at first appearance on this case, frankly, if Ms. Pulliam is being represented by somebody on a conflict situation, that same situation would obtain as to this.
Okay, so she should be represented by Miss McLeod. What was your announcement on 26, Brianna Marks?
She is in Gwinnett County, and last week, I think we had trouble getting hold of her by Zoom.
Okay, so unless she appears, position 26 will be reset to the next SAP calendar, which will be March 12, March 19.
Right, it's just that that's already happened once because of our location,
Right.
but we understand.
So going back to position 29, Bernard Rancher.
Negotiated plea for Mr. Rancher.
Okay, Jalen Riddle is released.
He's released, right, I'll strike that out.
James Spann.
That's a negotiated plea, Your Honor.
Okay. Then 33, Nafisia Stewart.
We were told they were released.
All right, released, question mark. Karina Stones.
Oh, they were released so early, Your Honor, that it was in the announcements from the state.
Okay.
A day or-
35, Antonio, I think is,
Right, and Miss Stone's number 34 is a not guilty possible bond request, and Antonio Tucker, 3537, is a negotiated plea.
okay, Karina Stones is a not guilty, okay. All right, if anybody's ready in the courtroom, I can take those cases up and then move on down later.
We have position number 31 and 32, James Bond.
Okay,
James Spahn is here, 31-2.
perfect.
James Spahn? Span, I'm sorry. We're doing a negotiated plea, is that correct? Yes, sir. All right. That's ready.
All right. I have an individual who's walking around with the phone B130DL. What case are you here for?
Hello, yes,
What case are
Charlicia,
you here for?
Charlicia Lurie.
Okay, when she shows up, could you then start your video because it's very distracting when you're moving around?
Okay,
Okay, please stop your video and then come back on. Thank you. All right. We are addressing positions 31 and 32 on the SAP calendar. This is State versus James Alex Spann, case number 21 CR 002567E, in which Mr. Spann's accused of battery, family violence from April 28, 2021. The second case, position 32, is a bench warrant matter 24 FTA 234. Mr. Spann, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea, and if the plea moves forward, your bench warrant will be null prossed or closed down. May I place you under oath, please?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. What is the recommendation, Mr. Pierre Thomas?
Good morning, Your Honor. The recommendation from the state on position number 31, Mr. Spann, is for the defendant.
Oh, I'm sorry, Mr. Pierre Thomas, your Wi-Fi is going in and out. That's not gonna work.
12 months on probation. I'm sorry. 12
Yes, your
on
Wi-Fi is going in
probation
and
to
out.
serve 30 days in custody. Credit for the 12 days that he's already served in custody. For the balance to be probated for him to complete a family violence intervention program. I'll try something else. One moment, Your Honor, I'm sorry.
All right, thank you.
2. 30 divided by 2 equals 15. 15 minus 12 equals what?
Mr. Pierre Thomas, I'm
Is
just
this better,
wondering,
Your Honor?
it is better. Let's try that again. It was 12 months to serve 30 days. Balanced probated, domestic family violence intervention program, and what else? Oh. No. Mr. Pierre Thomas, we can't hear you. Perhaps if you switch off the video, your audio may come out clearly.
40 hours of community service, no further contact with my
All right. Yeah, the audio is not working out. Let's try that.
Is it better now?
Let's try that. Okay. So 40 hours of community service.
Give me 1 minute, Your Honor. I will just restart the box.
Okay. All right. Let's see. Is Miss Falk with us yet?
The no further contact with Markendra Mays. A stay away from 505. Let's see.
Mr. Pierre Thomas, why don't you leave the Zoom and see if that would help and just come back in. Okay, Miss Strong did. Okay, Miss Grace, did Mr. Pierre Thomas leave the Zoom?
He did.
Okay,
Yes,
we'll
Judge,
just
I
wait
don't
until
see
he comes back in. Okay,
No.
yeah. All right. Mr. McLean, while we're waiting for the prosecutors to come back to the Zoom, let's see now. You were announcing on position 35, Townsend,
35 is Tucker.
Tucker, excuse me.
That's a negotiated plea.
All right. And Townsend?
Townsend, I'm not familiar with, Your Honor.
Okay. I have another Antonio Tucker, same person, or is that his bench warrant?
Same person, that's his bench warrant. I mean, that's.
And
Yeah.
you don't think Anthony Townsend may be the same person? No.
What are we looking like for a booking number there?
Okay. Colby Walding?
Your Honor,
Oh, there you are. Okay.
I switched internet sources. That should fix the problem. I've went to my hotspot now.
Okay. All right. Let's get back to James Spann. So I heard balance probated FVIP 40 hours, no contact with Macrinda Mays, and stay away from.
Yes. 505 Hampton Drive, Sandy Springs, no firearms, and the completion of an ADET. And then also if we can give him credit for the 12 days that he's already served in custody.
Yes, got that. Okay.
And I'd just like to say that our office has not been able to get in contact with the victim And so if we could sound for her and then get the defense to stipulate to venue, factual basis, and ID.
Macrinda Mays? All right, Mr. McLean, do you so stipulate?
We do so stipulate for the purposes of the plea. We anticipate that he will be out Friday night or Saturday morning, based on 3 days.
Okay. And Mr. Span, have you let me place you under oath again, I can't recall. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Has it been explained to you that in order for you to enter this plea, you would have to give up your constitutional right to a trial before a judge or a jury, to not be able to go back to court, have an attorney assist you, challenge the evidence brought against you, confront your accuser, and have the state carry its burden to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Yes.
Your sentence is 12 months to serve 30 days, credit for time served 12 days. As you've understood, you will be serving additional time before you are released from the Fulton County Jail. Upon your release, you will report to probation next Thursday, which will be, oh, excuse me. Yeah, I'm going to make it next Thursday because your release date's a little later. And I'm trying to get the date, which would be March 21st. And you will go to 132 Mitchell Street in downtown Atlanta. That's where the probation office is located. You will begin probation, where you will report to probation every month. You will enroll in a domestic violence intervention program, and you must enroll in that program within 60 days of being released. You will start completing 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin those hours within 30 days of being released, and you must complete at least 5 hours per month. You are to have no contact with Macrinda Mays. You are to stay away from 505 Hampton Drive in Sandy Springs. You're not allowed to own any firearms. And within 90 days of being released, you will submit to an alcohol and drug evaluation and submit yourself to any treatment that's required. You may do that with any qualified healthcare provider, including Grady Hospital. Any questions?
No, but I think I got a hold in Marietta. When I be released,
If you're going to
I'm sorry, Your Honor, if he has a Cobb County matter or a Marietta City matter, then we should just simply tell him as soon as he gets out, go over to 132 Mitchell.
Yes, that would be it. As soon as you're released by Cobb County, you are to report to your probation officer in Fulton County with the next immediate business day, and they're open on Monday, Tuesdays, and Thursdays.
Monday, Tuesday, and Thursday.
Yes, sir.
Thank you.
And the bench warrant matter is going to be null prost. Okay, next case, please.
Position number 35 and 37, Antonio Tucker.
Thank you.
Somewhere in there. That's
Is Anthony Townsend the same person as Anthony Tucker?
This is Antonio Tucker. I don't think so, Your Honor.
Okay, so it's 35 and 37. Okay. Position 35 is case number 21 CR 005-861E, State versus Antonio Tucker, on which he's accused of criminal trespass from February 10th, 2021. Position 37 is Mr. Tucker's bench warrant, 24 FTA 000226. These are the two matters involving him. All right. Mr. Tucker, you can advise, yes, Mr. McLean?
Your Honor, was 21, number 35, that was 21 CR 005-861F.
Position 35,
It's an E.
5861E as in England.
Okay, thank you.
Mhm. Mr. Tucker, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a non-negotiated plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you.
I apologize. Is this a negotiated plea or a non-negotiated plea?
I
Uh,
heard negotiated.
Negotiated is what I've got.
Okay,
Mr. Tucker, this is what we're doing, right? Time served, balance suspended? Yes. It is negotiated.
all right. In that case, Ms. Falk, if you'd like to proceed.
Yes, Your Honor. On position 35, the criminal trespass, the recommendation is 12 months served, 24 days, credit for time served 12 days. That's from March 1st to March 12th of this year. Balance suspended, stay away from Eon, EON, located at 2470 Camellia Lane in Atlanta, Georgia. Position 37 is going to be null prost upon the taking of this plea. That's all for the state, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
For the purposes of the plea, we do.
Mr. Tucker, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Has it been explained to you that in order to enter this plea, you would have to give up your right to a trial in front of a judge or a jury? You will not be able to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Yes.
Your sentence is 12 months to serve 24 days, credit for time served 12 days, balance suspended. You are not to return to the building identified as Eon, EON, at 2470 Camellia Lane in Atlanta, Georgia. If you return to that location, you will be arrested again. Thank you.
Thank you.
And your bench warrant is closed out. Thank you.
Not good news. So, you keep that on.
Next case, please.
Position number 23, Mario King.
Mario Keen, Keen, 23.
This is State versus Mr. Keen, first name Mario, case number 24CR 898A, accused of simple battery, family violence from February 25th, 2024. Mr. Keen, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And this is going to be a a negotiated plea. Would that be correct?
Well, Your Honor, it could be a counter offer or not. We're pretty flexible. He just doesn't want the 14 extra days. And if the state is okay with that request, it's negotiated plea. If not, we'll proceed with non-negotiated.
We'll need to go ahead and proceed with a non-negotiated plea on this, Your Honor.
All right.
Sure.
Mr. Keen, so on a non-negotiated plea, I'm going to first hear from the prosecution as to their recommendation, and then I will hear from your attorney. I will make a decision as to which recommendation I'll accept and let you know. At that point, you can decide whether you want to move forward with the plea or whether you would like to enter a not guilty and have the case set for trial. Ms. Paul?
Yes, Your Honor. Can we have pretrial go over the history, please?
Of course. And that would be Ms. Washington. Good morning.
Good morning. Your Honor, I see 32 arrest cycles. One moment. There is a 1996 death by receiving stolen property.
Anything more recent in the last 10 years?
Yes, give me
Violence?
one moment. There is a 2018 entering auto, 2 counts of that, and that was out of Clayton County. There's also a Fulton County entering auto, and that was in 2016. A 2014 criminal trespass, misdemeanor conviction.
Yeah.
And that's all that I see within the last 10 years, no violent conduct within the last 10 years.
All right, thank you. Ms.
Thank
Falk?
Yes, Your Honor. I would want to point out that in 2009, this defendant was convicted of aggravated assault, theft by receiving stolen property and fleeing and eluding, and did receive a sentence on that case. So although there is not a history within the last 10 years regarding violence, there is a history of violence here. So I wanted to point that out before I give the facts on the record. This incident happened February 25th of 2024. Officers made contact with Tracy Satterwhite at 1033 Hollywood Road Northwest. She stated she returned home to her residence after being gone for a few days, and the defendant, who's the father of her child, was upset with her, very irate. He began shouting things like, "Go back to wherever you've been." When she attempted to enter her residence, he attempted to hold the door closed from inside. Since he was trying to physically hold the door closed, she then forced her way inside the residence. He then snatched the hair off her head. And when the officers arrived, he advised that nothing happened. And the officers then placed him under arrest for simple assault. We did have an opportunity to speak with Miss Tracy Satterwhite. She did say she will not be on Zoom. She agrees with the plea offer that we have made. She stated she is tired of the defendant and his abuse. She stated she's been dealing with him for 23 years and she just wants him to stay away from her and leave her alone. And so for that reason, the state is making the offer of 12 months served 60 days, credit for time served 16 days. That's going to be from February 26th to March 12th of 2024. Balance probated, family violence intervention program, no further contact with Tracy Satterwhite, stay away from 1033 Hollywood Road Northwest, 40 hours of community service, and no firearms. Again, Your Honor, I just want to point out he has 32 cycles. He does have at least one aggravated assault conviction. So this recommendation is fair in light of his history. That's all for the state. We would like to sound from Ms. Tracy Satterwhite.
Ms. Satterwhite? Right. So it'll be 60 days, and how many more days will be left? I think about, am I correct, Mr. McLean? He would have about 12 more days. Am I off? I think
I think 14.
14, okay. 14 more days, so he has 2 more weeks at the jail. All right, and what's your recommendation, Ms. McLean?
Well, I will demur from saying whether or not those feelings are mutual, because some of the responses of Ms. Satterwhite apparently were she's tired of him and that sort of thing and not going to put up with it anymore. Your Honor, I did hear in the 2018 entering auto 2 counts from another county and the 2016 entering auto those were arrests, I infer, because I didn't hear the word convictions like I did here after the criminal trespass of 2014, and the state provided the ag assault, et cetera, conviction of 2009. I don't know if the 1996 theft by receiving was merely an arrest or a conviction. You know, he's asking the court to consider giving him time served as the jail portion of his sentence, even if the court feels that it would be fair to counterbalance that by going up and adding special conditions. He would like to be out. It is a simple battery family violence. He's not denying it. He's taking responsibility, and he does want to get on with his life, and he would prefer to be in freedom this week rather than 2 weeks from now, but he's going to lay it in the mercy of the court. And
Can I go back to what you said at the beginning? What was that about Miss Satterwhite? That
Miss-
you're not convinced that she doesn't want to have contact with him, or
Please.
he's not convinced?
the state, no, I said the state was announcing that she's fed up with him, tired of him.
Yes.
Don't see him
What
anymore.
was the comment about that?
I said I will demur from saying whether the feelings are mutual. Because those are, a lot of that is feelings, and really, they're not going to be in contact. Sounds like a toxic relationship. So they're not going to be in contact with each other at all.
See, I'm not convinced of that. I have a feeling that Mr. Keene might return to the property and attempt to communicate with her.
Well, she was the one that was trying to come in, and he was saying go away. So
I think they cohabitate together. That was the allegation.
That is correct, Your Honor.
So that's my concern.
now he is very,
He is going to be right back in jail if he attempts to communicate with her or have any contact with her?
He agrees. He will be right back in jail if he attempts in any way to contact her. Not even smoke signals from a hillside.
I'm going to accept the defense's recommendation, but the court I'm going to be very emphatic, Mr. Keen. If there is even a whisper, from Miss Satterwhite, that you attempted to communicate with her or that you returned to the property, probation can simply fill out a warrant and you'll serve out the rest of the year in prison. It's that simple. First of all, where will he be living, Mr. McLean?
I'm sure he has friends or family to stay with, Your Honor. He will not be around there.
Does he have an address at the present time?
I believe that I wrote it down in my contact information, Your Honor. I think initially he's going to be staying with other family.
All right, I'll accept the defense recommendation on the grounds that it is a simple battery. And it's a question of 2 more weeks. I'm not certain if 2 more weeks is going to rehabilitate someone with 32 arrest cycles.
Correct.
And Your Honor, in an effort to perfect the record, because I did omit, I was just going over the GCIC again. This is actually, he has 2 previous aggravated assault convictions, one from 2007 and one from 2009.
Oh,
And so I know that would likely not change the court's position, but out of, just an effort to perfect the record, I wanted it clear for the court. This is not even his first aggravated assault in 2009. He has the previous one in 2007, where he received domestic violence intervention program as a condition of that aggravated assault.
no, I understand. And considering that, like I said, even with his 32 arrest cycles, appears that the violent convictions are more than 10 years ago. He's had a couple of hiccups with theft convictions in 2016 and 2018, but the court is going to place him on probation. He is going to be reporting every month. He'll need to be up to date with his address, his fees, his classes, and so forth. Otherwise, probation is authorized to issue a warrant against him. And I'm sure, Ms. Falk, this is not his first rodeo with probation, so I'm sure he understands the importance of being compliant. Mr. McLean, shall we proceed?
Yes, Your Honor, please.
All right. Mr. Keen, please raise your right hand. Do you solemnly, you have a question?
I just want to know what I'm taking, what's going on. I'm listening.
You don't understand?
I want to get a clear understanding of what's going on.
All right. The clear understanding, or rather the court is accepting your attorney's recommendation that you serve 32 days, credit for time served 16 days, which means that if you don't have any more holds at the jail, you'll be released within 24 hours. You are not to return to 1033 Hollywood Road. You're to stay 200 yards away from that location. You are to have no contact with Tracy Satterwhite. You have to stay 200 yards away from her and not communicate with her in any way, form, or manner. You will be reporting to probation next week, next Tuesday, and within 30 days of being released, you are to enroll in a domestic violence intervention program. You are to complete 40 hours of voluntary community service. Considering your felony convictions, you're not allowed to own any firearms. You are not to own any weapons, and your community service and your classes must begin within 30 days of being released. And that's the court sentence, a proposed sentence if you decide to accept the guilty plea, if you decide to enter a guilty plea. Would you like to move forward, or would you like to enter a not guilty and be scheduled for trial?
I would like to get it all over with,
That doesn't answer my question.
I want to take.
Would you like to enter a guilty plea and accept that sentence, or would you like to plead not guilty and move forward with trial?
Accept the plea.
Okay. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Keen, have you consumed any alcohol or medicine recently?
No, ma'am.
And after the court's explanation and your conversations with your attorney, do you now understand what's going on in your case and what you will be accepting?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea?
No, ma'am.
Are you entering a guilty plea freely, willingly, and knowingly?
Yes, ma'am.
And you understand that if you decide to enter a guilty plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the assistance of counsel to confront your accuser, challenge the evidence brought against you, present your own defenses or mitigating factors, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery, family violence?
Guilty.
Your sentence is 12 months to serve 32 days. Credit for time served, 16 days. The remainder of the time will be on probation. You are to report to probation next Tuesday at before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. Within 30 days of being released, you are to enroll in a domestic violence intervention program, and you are to continue attending those classes every week until it is completed. You are to have no contact with Tracy Satterwhite. As I've indicated, you're to stay 200 yards away from her. Do not communicate with her in person through mail, email, phone, computers, social media, and even through a third party. You're also to stay 200 yards away from 1033 Hollywood Road in Atlanta, Georgia. Within 30 days of being released, you will also begin your community service hours. You have to complete 40 of them. And you are to begin at least complete 5 hours a month. Do you understand, sir?
Yes, ma'am.
You're not allowed to own any firearms or any weapons. And if you're also not allowed to consume any illegal drugs and no alcohol. You will be subject to random screens by your probation officer for illegal drug substances or consumption of alcohol. Within 30 days of being released, you will come to the court and update your mailing address in writing. Do you understand, sir?
Yes, sir.
You are to provide a new, your current mailing address to the court as well as to your probation officer in writing. Do you have any questions about your sentence?
No, ma'am.
All right. As already indicated, and probation is on notice that if you violate any of these conditions, if you fail to enroll in the classes, if you fail to begin your community service, or if you attempt to contact Ms. Satterwhite in any way, probation is authorized to issue a warrant for your arrest and revoke your probation. Understood?
Yes, ma'am.
Thank you.
Thank you.
Okay, is that a free? Yes. Okay, cool. Now,
Ms. Vigilante, are you ready to go?
Forum 2, who's next?
We could go to position number 6 with,
6. Okay.
that's Ms. Vigilante's fine.
I thought that-
Freeswell, Collins.
Hmm.
Good morning, Judge.
Good morning, Ms. Vigilante. All right, and we have your client, Danelle Collins.
Yes.
All right. Mr. Collins, your case number is 16 CR 011122D. This looks like traffic-related charges stemming from a November 4th, 2014 incident. The charges are driving while license suspended or revoked, operating a vehicle on a divided highway, and a failure to maintain lane. Mr. Collins, you have been advised of your right to remain silent, and your attorney is Ms. Vigilante. Ms. Vigilante, is this involving a commercial driver's license?
I don't believe so. No, Judge.
All right, okay. Mr. Collins, this is going to be a negotiated plea, I understand, so may I place you under oath? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Ms. Falk, what's the recommendation, please?
Yes, Your Honor. The recommendation on this case is on count 1, 12 months with 16 days to serve, credit for time served 8 days. That's going to be from September 5th of 2024 to, that would take us out to September. Let me just check on that date. For some reason, that does not sound correct, the September date. September 4th hasn't happened yet. So,
Well, I'm famous for typos too, so.
so I'm going to go ahead and say March 5th, 2024 to today's date. The recommendation also includes a $500 fine. We are agreeable to terminating probation upon the payment of the fine. Count 2 would be 12 months probation terminated upon the payment of the fine, $265 fine concurrent with count 1. Count 3, we will be tendering a null pros upon the taking of this plea. So the total is 12 months served 16 days, credit for time served 8 days, balance probated, a $765 total fine, and the probation shall be terminated upon the payment of the $765 fine. That's all for the state. We would ask the defense to stipulate to factual basis, venue, and identification for the purposes of this plea. And I did verify it is March 5th, 2024 to today's date.
All right. Ms. Biglietti, do you so stipulate?
We do.
All right. And does your client have any particular holds that might inhibit his ability to report to probation or pay the fine?
Yes, he is being held without bond. He'll be released to either Smyrna or Douglas County. But we've discussed probation. He understands as soon as he's actually released, he's gonna report to probation and pay those fines.
So you understand, Ms. Falk, that he's got a hold in Douglas County, and that's no bond. And he's got a hold with Smyrna Police Department, no bond.
I'm not sure what the basis of those holds are, if they're traffic offenses or more serious offenses.
Okay.
Because, I mean, if they're traffic offenses, he's going to go through the process, he'll be out, and then he can pay the fines.
I doubt it. He's got no bonds on those. So,
Well,
all right. He'll have to be picked up by, let me see. Sometimes,
Your Honor, I can see the holds if you want me to.
yes, please.
Yes.
Okay, so there is a hold here for Smyrna, and that was for a failure to appear from 2015. There's also one from Streetsboro, and that was for a traffic offense, and that was from 2022. And also there's one from Bedford Heights, and that's for a failure to appear, and that was from 2023, April of 2023, and that was in Ohio. And then there's also another one from 2015 for driving with a suspended license, and that was in Douglasville. So there are a total of 4 here that are listed.
My goodness. So though I'm looking at the Smyrna hold, and it says please hold and send locate. So looks like he might have to be picked up. I recommend that see if Smyrna will come and pick him up, because that's what's going to keep him at the jail. He cannot leave on his own reconnaissance. So knowing that, would he still like to move forward with this plea?
yes, Judge.
All right. Mr. Collins, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes.
I can't hear you. Could you speak up?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And is anybody forcing you, inducing you to take this plea?
No, ma'am.
If you decide to enter this guilty plea to these charges, Please understand that you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And entering a guilty plea today to driving while license suspended or revoked from 2014 will trigger another license suspension. Do you understand? Which means I don't know if your license is currently valid, but if once you enter this guilty plea and it's filed with the Department of Driver Services, you will not be able to drive for the next 6 months to a year
Yes, ma'am.
until you get your license reinstated. Do you understand that?
Yes, ma'am.
How do you plead to one count of driving while license suspended or revoked, a divided highway or controlled access road violation, and failure to maintain lane?
Good.
Right. Your sentence on driving while license suspended is going to be 12 months to serve 16 days, credit for time served 8 days. And you'll be placed on probation. That means as soon as you resolve your multiple holds, you must report to Fulton County Probation on the first available business day, which will be Monday, Tuesday, or Thursday. You must report before 3 p.m. And while you're on probation, you have to pay a $500 fine for driving while license suspended or revoked, and a $265 fine for divided highway. And excuse me, I made an error. You are not pleading guilty to failure to maintain lane. That charge is going to be closed out or dismissed. Okay, so you are being convicted of 2 offenses: driving while license suspended and divided highway or control access road violation. Once you've completed paying your $765 fine plus any outstanding probation fees and surcharges, then your probation will terminate. You are not to operate a motor vehicle unless you have a valid and current driver's license, adequate insurance, and proper registration for the vehicle you operate. Thank you.
Thank you, Judge.
I guess he will have to be released to the whichever hole picks him up first. Most likely Smyrna would be the closest,
Okay, thank you.
the most expedient, I think. All right. There's a person named Sean who's just joined. Could you unmute and let me know which case you're here for?
I'm here for Devin Flowers, my
Okay.
brother.
Could you please mute and stop your video until that person's name is addressed?
Yes, ma'am. Sorry about that. Thank
That's
you.
all right, thank you. Ms. Vigiletti, who do we have, please?
Position number 7 and 8, Brian Criswell.
Thank you. Brian Cresswell is case 23 CR 3740Y, accused of criminal trespass from June 12, 2023. And he has a bench warrant 24 FTA 231 from October 19th, 2023. Mr. Cresswell, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. This is going to be a negotiated plea. Would that be correct?
Yes, Judge, just very quickly, Ms. Fox, I sent you an email. It was last night, though you may not have seen it yet. Just asking if you'd be agreeable to a non-reporting probation, since this probation recommendation doesn't have requirements aside from staying away from the church.
Yes, I'm fine with balance suspended instead of balance probated.
Okay. All right. Shall we proceed?
I'm sorry, Judge, just 1 second. My client.
Okay.
Okay, thank you, Judge. We are prepared to proceed with the plea today as negotiated.
Mr. Cresswell, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Can't hear you. Can't hear you.
Yes.
Thank you. All right, Ms. Vigilante, excuse me, Ms. Falk. On the trespass, what's the state's recommendation?
State's recommendation is 12 months served 22 days, credit for time served 11 days. That's going to be from June 13th to June 14th of 2023 and March 4th of 2024 until today. Balance suspended. Stay away from 265 Washington Street Southwest, Atlanta, which is the Trinity United Methodist Church. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And I did neglect to state that we are null processing position
Of course.
8.
Yeah, okay, thank you. Ms. Vigilante, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right. And is this Methodist church his church? Is that where he usually goes, or does he have
Yes.
another place he can go to?
Yes, and we spoke at length yesterday. He understands he cannot go back there.
I was,
Sorry. Yes, we did speak at length. There was a misunderstanding. He did believe he had permission to be there. He understands that he does not have permission to be there. He could not be there anymore. And so I think we are prepared to move forward. Oh, and I'm sorry, Mr. Cresswell is telling you that he used to sleep there and he believed he had permission to sleep there, and he understands now he does not.
Okay. Mr. Cresswell, have you consumed any medication or alcohol recently?
no,
You need to speak up, okay? Because I know you're wearing the mask, but I need to hear you.
no,
And are you satisfied with your attorney?
yes,
Repeat.
yes,
Right. And is anyone forcing you to enter a guilty plea just to get out of jail?
no,
And do you understand that if you decide to plead guilty, that this will be a conviction on your record?
yes,
And do you understand that you will not be able to have a trial to challenge this charge in a court of law? You will not have the assistance of counsel to go back to court, have a trial, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt.
yes,
Repeat.
yes,
So you are willing to give up these rights?
yes,
How do you plead to one count of criminal trespass at the Trinity United Methodist Church?
yes,
What was that?
yes,
Just one more time, just speak up real loud.
guilty. God said, I'm saying, so he said, oh, he gonna say it, so he gonna say.
I just want to be sure that you understand that you're pleading guilty to a trespass at the Methodist Church and that you're not allowed back there. Do you understand that?
Yes,
Your sentence is 12 months to serve 22 days, credit for time served 11 days. If you have no other cases holding you at the jail, you'll be released within 24 hours. The remainder time is suspended. That means you do not have to be on probation at all. You have served your time for this sentence. However, you are still on notice that the church at 265 Washington Street in Atlanta, Georgia, the Trinity United Methodist Church, has required you to stay away from its location. So if you go back and sleep on the steps or you try to enter that church, they will ask you to leave, and if you do not, they will have you arrested.
okay, Judge, so. Yeah,
Well, that was the loudest I've heard from him. Do you have any other questions, or do you want to talk to your attorney?
no, I don't have.
All right, find another Methodist church.
I don't
There are
know.
lots of them. Thank you.
Judge. Thank you.
Next, we have position number 11, John Davis.
I have also someone at Jail Court iPhone. Jail Court iPhone, who do we have?
We have position number 29. Mr. Rand.
29. Mr. McLean, I think that's your client.
That's negotiated.
Yeah.
I'm just wondering whether he needs to talk to him. I can put them in a breakout.
Oh,
No.
Mr. McLean is saying that they're ready and Mr. Rancher will be taking a plea today.
Okay, I'll address that shortly. Let me address, position, what was this? Position 13?
John Davis, I was told yesterday that he was released, but thankfully our courtroom officers looked for him anyway and found he was not released. So
Okay.
appreciative of that.
All right, and are you ready to move forward with this case?
Yes, Judge.
All right, position 11 is State versus Davis, 24 CR 9328, accused of criminal trespass and willful obstruction of an officer from February 26th of this year. How are we proceeding, Ms. Vigilante?
Mr. Davis would like to enter the plea as negotiated today.
All right, Mr. Davis, you have been advised of your right to remain silent, and your attorney is Ms. Vigilante. May I place you under oath?
Yes, ma'am.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on count 1, the criminal trespass, is 12 months, serve 30 days, credit for time served 15 days. That's going to be from February 27th of 2024 until today. Balance suspended. Stay away from Truist Bank, located at 303 Peachtree Center Avenue. As this is a balance suspended plea, we are striking the MHET request. Count 2, 12 months probation concurrent with count 1. The state is going to ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
So stipulated.
Mr. Davis, have you consumed any medicine or alcohol recently?
Medication for while I'm in here incarcerated.
Okay. And after consuming that, are you still able to understand what's going on and understand your conversations with your attorney?
Yes,
Are you satisfied with your legal services?
yes,
Are you entering this plea freely, willingly, and knowingly?
yes,
You understand that if you decide to accept this plea, you will have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to 1 count of criminal trespass at the Truist Bank?
yes,
How do you plead to willful obstruction of a law enforcement officer?
yes,
Your sentence on the trespass is 12 months to serve 30 days, credit for time served 15 days, balance suspended. You are to stay away from the Truist offices located at 303 Peachtree Center Avenue in Atlanta, Georgia. Count 2 will be concurrent with count 1. Your jail time or your sentence for these 2 charges are concluded. However, if you return to that Truist Bank, you will be arrested again. Thank you.
Thank you, Judge.
Mr. McLean, we can address your client, Mr. Rancher.
Bernard Rancher is ready for his negotiated plea.
All right, sir. Mr. Rancher, please sit up straight. Thank you. All right, Mr. Rancher, my name is Judge Lal, and we're going to be addressing your case 24 CR 1014B. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Michael McLean. Do you see Mr. McLean on the screen?
no, ma'am.
You do not? Okay.
I'll wait.
I feel
So
nice.
do you see him now?
Yes,
See you
ma'am.
now.
All right, great.
Very good, thank you.
Mr. Rancher was accused of theft by shoplifting and willful obstruction of an officer from January 8th, 2024. Mr. Rancher, this is going to be a negotiated plea hearing. May I place you under oath? Raise your hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you.
I do.
All right. Can you hear me all right?
Yes, ma'am. I did the little thing kind of
kind of blurry a little bit because of the light in the jail, that's all.
Okay, as long as you can hear us, that would be good. Thank you.
Yes, ma'am, I can hear you.
Ms. Falk, what is the recommendation?
Yes, Your Honor, the state's recommendation on count one, the theft by shoplifting, is 12 months, serve 128 days, credit for time served 64 days. That's going to be from January 9th to March 12th of 2024, balance probated. There will be an anti-theft course, 40 hours of community service, stay away from the Family Dollar located at 3721 Campbellton Road Southwest in Atlanta. On count two, the willful obstruction of an officer, we are requesting time served 128 days, credit for time served 64 days. That is to run concurrent with count one. The state is asking the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And that is all for the state.
And for those purposes, we certainly do stipulate, Your Honor.
And Ms. Falk, do you know if he has any prior shoplifting convictions on his record?
I can
Oh, I
look.
could ask Ms. Washington. Ms. Washington, this is position 29.
Your Honor, I am seeing, it looks like this case, because I was looking at the amount of time he served, it looks like this case may have been transferred down from the felony division in the DA's office, but I just need to, it's just taking a moment to load up. Let me just take a look at the notes on this.
And while she's looking at her notes, I do see a 2014 arrest here in Fulton County for theft by shoplifting. It does not show whether that was a conviction. Also, I do see a 2018 theft by shoplifting. It does not show whether that was a conviction either, but the dates are separate. And here also another theft by shoplifting, and it does not mention whether that was a conviction in 2023.
All right, I just poked my curiosity considering the time spent.
Okay. And yes, Your Honor, that is correct. The DA's office originally had this case, and the transfer order was signed. It was finally sent down to state court, and we received that case. It looks like we received the case on February 29th of 2024. It was reduced and transferred to us according to our notes, and we worked up the case and then had it placed on the next available calendar.
Thank you.
Can I say something, Judge?
No, not this time.
Go ahead, Mr. McLean.
I would like for us to go forward, Mr. Rancher. It's not
Yes, sir.
not a general
Yes.
discussion or Q&A period. Thank
Yes,
you.
sir. Yes, sir.
All right. Mr. Rancher, have you consumed any medicine or alcohol?
Talking about today, ma'am?
Recently?
No, man, I took my blood thinner medicine this
Okay.
morning for pill call.
And after taking the medication, are you still able to understand your attorney and what's going on so far in your case?
Yes, ma'am, I do.
Are you satisfied with your legal services?
Yes, ma'am, I do.
And is anybody forcing you or inducing you to plead guilty today?
No, ma'am, they did not.
And as you've just heard, I was curious to know about your criminal record history, especially when it comes to shoplifting, given
Yes,
the allegations of the sentence that you have been in custody for 64 days. Please understand that with respect to the law, that
ma'am.
if you have 3 or more shoplifting convictions on your record, any
Yes, ma'am.
subsequent arrest for shoplifting is automatically a felony.
Yes, ma'am.
So that perhaps explains, or maybe there may be another explanation of why you were first being tried as a felon rather than a misdemeanor offense. Do you understand?
Yes, ma'am, I do.
Well, you also need to understand that if you decide to plead guilty, that this will be a shoplifting conviction on your record, that you would also have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to have the assistance of counsel to go back to court have a trial, challenge the charges brought against you, and have the state carry its burden to prove the charges brought against you by proving the charges beyond a reasonable doubt. Are you prepared to
Yes.
give up these rights?
Yes, ma'am, I am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am, I am.
How do you plead to one count of theft by shoplifting and one count of willful obstruction of an officer?
I plead guilty, ma'am.
Your sentence on the shoplifting is 12 months to serve 128 days, credit for time served 64 days. And that would conclude your jail time. If you have no other holds, you shall report to probation next Tuesday, which is March 19. You will
March
report.
9th.
That's right. You will
Yes, ma'am.
report before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. Within 60 days of being released, you are to enroll and complete an anti-theft class. You're
Yes, ma'am.
also to begin 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. You must begin that community service work within 30 days of being released, and you must complete at least 5 hours a month.
Yes, ma'am.
At all times, you're to stay away from the Family Dollar store located at 3721 Campbellton Road in Southwest Atlanta.
Yes,
With
ma'am.
regards to the obstruction charge, the sentence is time served, which is 128 days, credit for time served 64 days. And that runs concurrent with count 1. Thank you.
And Your Honor, just to put on the record for clarification, it appears that the initial warrant that was taken out alleged the amount was over $500. And then that was eventually, for whatever reason, and the state is not sure why, reduced down to a misdemeanor and sent to us.
All right. Thank you. Next, please. Yes.
Before we get to Mr. McLean, I was informed that Mr. Rakeem James, positions 20 and 21, waived his appearance.
I have down that was a waiver of presence and arraignment. That is correct.
Okay.
All right. Thank you, officer.
You're welcome.
Mr. McLean, who is seated next to you?
This is number 12, Your Honor. I'm not in that area of the calendar.
Okay. Mr. McLean, before I let you go, is there anyone at ACDC with whom you need to speak?
Ms. Stones is ready. No, Your Honor, I don't believe so.
Okay, just want to be sure. Thank you. All right, Ms. Vigiletti, we have
Position number 12, Your Honor.
12. Thank you.
Yes, Judge, and I have an updated announcement on this case. I know I announced that Mr. Dawson would be entering a plea today, but we spoke again this morning and Mr. Dawson would not like to enter a plea today.
Okay, so we'll go ahead and arraign the case. Do you waive a reading of the accusation?
I do.
All right. This is State versus Mario Dawson, case number 24 CR 916D. Mr. Dawson is accused of simple battery from February 26, 2024. Mr. Dawson, this is a misdemeanor offense of which you're accused, and upon your entry of a not guilty plea, the case will be further noticed for trial before a judge or a jury. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does prevail, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
This case has been arraigned and further notice for trial. Thank you.
Thank you, Judge.
Probation 3 and 4, Flowers.
Mr. Flowers?
No.
On probation.
Officer Brooks, good morning.
Oh, I'm sorry.
Good morning, Your Honor.
Flowers. I'm sorry. Flowers is a probation case, Your Honor.
Yes,
I believe
sir.
the recommendation is going to be amenable to him.
Understood. All right. Officer Brooks, may I just swear you in, please? Do you
Yes, Your Honor.
solemnly Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. This is
Mhm.
State versus Deshawn Flowers, positions 3 and 4 on the probation revocation calendar. The original case is 22 CR 005-864J, in which Mr. Flowers was convicted of simple battery. Position 4 is his probation revocation case, which is 24 PB 314. Mr. Flowers, you have a right to remain silent. Anything you choose to say about the circumstances of your case, your statements can and will be used against you. Okay, just one second. Miss Grace, could you please remove Sean from the Zoom? He is driving.
Okay, Judge.
Thank you. Just remove him from Zoom. Thank you. And then when he's parked, he can log back in. As I was saying, Mr. Flowers, you do have a right to remain silent. You also have a right to an attorney. If you cannot afford one, Mr. McLean will be representing you as your appointed counsel. Ms. Brooks, you have been sworn. What is the basis for the warrant, and when was he convicted, and what's the recommendation from the state?
Thank you, Your Honor. He was seen on March 27, 2023 for simple battery in front of Judge Batson. He was court-ordered to complete 12 months of probation and to complete an 8-week anger management program. He reported on April 27, 2023 for that one time. He never reported again. He didn't complete the anger management. He was also scheduled a probation revocation hearing on June 21st, 2023 that he did not show up to, which is when his warrant was placed for his arrest. He has 277 days remaining on probation, and he currently owes $147 in probation fees, Your Honor.
And the recommendation from probation?
1 second, Your Honor, my apologies.
Revocation.
Oh, I'm so sorry. Give me
That's
just
all
one
right.
second. Let me see what they recommended for him.
I can tell you.
So let Ms. Brooks do the announcements. Thank you, Mr. McLean. Appreciate it.
Okay.
I'm sorry, Your Honor. I need just a minute. I need to see what they recommended. My apologies. I thought I had it.
Okay.
Give me just 1 second.
Mr. Flowers, did you have a question to ask of your attorney?
Yes, ma'am.
All right.
We can, well, I think it's best for him to wait on the announcement of the recommendation. And when he finds out what's happening, I don't think he'll have a question other than logistics.
I just wanted to let you guys know that I was incarcerated the whole time. I have a proof of incarceration. I was incarcerated since June 28th with a probation hold up on me in Clayton County. I was incarcerated for 8 months.
Mr. Flowers, did you get what I was saying? Just wait on the recommendation to be announced, and then you may have a question as to what date. Okay?
Okay.
And while we're waiting on Officer Brooks, who do we have at Jail Court iPhone? I just want to make sure who's next. Jail Court iPhone, who do you have there? Oh, the officer may have stepped away. Officer Brooks, are we ready to proceed?
I'm sorry, Your Honor, I was trying to locate it. It's to continue for him. My apologies. I just
No
got a
problem.
response. We're continuing him on probation.
All right. And Mr. McLean, do you have any comment about that?
I don't have a comment, Your Honor, as long as Mr. Flowers understands that that means that they will release you from jail and expect you to complete all your promises that you made on the day you were sentenced and do the probation correctly, okay? He does have.
Yes, sir. I have a question. So when will my probation be? When would I be off probation? Because my probation expired March 27th of this year. I was incarcerated the whole.
No, it didn't. It didn't expire.
No,
It
it
didn't
expires.
expire. You have 277 days left.
I was incarcerated, Judge.
Well, not for this case.
Yes, I had a probation hold in Clayton County. I had my proof of incarceration. I couldn't bond out because I was sitting in Clayton County, but my family ended up bonding me out.
On this case?
Yes, but I had a hold the whole time I was in Clayton County.
All right, so I think you would need to speak to your attorney because Mr. McLean, if I continue him on probation, if he's on hold for this case, then I should give him credit for time served. But if he's been on hold because he was arrested on something else.
And we would be,
Roberto, could you please stop your video? Okay, thank you. Yeah.
we would be glad to research the other county records for that,
Yeah.
Your Honor.
I'm curious to know why he was arrested in Clayton County. And whether he was serving out a sentence or whether he was there on a new charge, because otherwise, we can address this later.
And also, Your Honor, we'll take a look at whether or not there was any tolling in this case.
And my only concern is that while he was in Clayton County, why didn't he contact his probation officer using a phone just to let us know where he was? So that's something else I'm really curious about. So
Yeah.
would we like to reset this case or are you?
Your
gonna-
Honor,
Yes.
I'm sorry, my apologies. I'm looking at the case notes for him,
Mhm.
and he wasn't incarcerated the entire time because he clearly has been having conversations with the previous officer on this case.
So but he only reported once?
Yes.
And what were the conversations in terms of why he didn't report?
Give me 1 second, Your Honor. Let me scroll back and I'll tell you.
I mean, if I'm going to continue him for another 277 days.
Correct. On May 25th, he said, y'all putting too much pressure on me. I ain't got no job no more. I'm homeless, trying to figure out my living arrangements. To be honest, them classes is the last thing I'm worried about. That was on May 25th when he had a conversation with the probation officer via text message. And then on May 25th, he responded again. I already had a court because the officer responded that he was going to give him a court date. He said, I already had court June 21st. This report to y'all every month is too much. Yeah, I need to speak to the judge anyways, because she said, once I complete them classes, I'm off probation. So he's been having conversations.
I see. Okay. Mr. McLean, I think you need to speak to your client because the whole idea is either to have him serve out the rest of the prison time in jail, or whether to continue him from probation.
I think I do need to speak to him, Your Honor.
I completely agree.
I don't think he's ready now.
All right. Would you be able to get on a laptop so that I can put you in a breakout session with medical?
Yes, Your Honor.
All right.
I can zoom in on my laptop or my phone, either one. I'll zoom in just a minute. I haven't connected to Zoom yet.
All right. Sean, are you related to this Flowers case? Is this the case you're talking about? All right, please start your audio and video. Sean, this will be the time. All right. Let's go on to jail court iPhone. Who do we have there? Is Sean still driving? Take him off Zoom. Remove him from Zoom. The man's still driving. Miss, yeah, thank you. All right. Jail court iPhone, yes, sir. Who do we have?
We have positions 44 and 45, Mr. Woodard.
Okay. Mr. McLean, I believe that's your case. Oh, no, that's Miss Vigiletti.
Yes, Judge.
Okay. Mr. McLean, please get on your device and we'll put you in a breakout. Medical deputy, we're going to put you in a breakout session so that Mr. Flowers can speak to Mr. McLean. Okay.
And Your Honor, I have an announcement on Jarvis Woodard. It appears that there are actually two cases on Mr. Woodard. There is a second case that had not been accused, and we did accuse it yesterday. It is 24 CR 001138J. That offense is also a theft.
And date of incident?
The date of that incident is, just a moment, Your Honor. The date of that incident was May 24th of 2023. The date of this incident on the calendar is December 30th, 2023.
Okay. And Ms. Vigiletti, are you prepared to address all three cases then?
So I guess my question would be, how does that impact the recommendation? Because as we talked yesterday, you know, I think the recommendation was maybe for one case, maybe not for both cases, so.
And I just I don't have any information on this while we're about to take this plea for this other case. If y'all just accused it yesterday, the only thing I have is the current. So y'all have, if y'all gonna take a plea on this, you have to give me time to be able to get this other information before we can do it.
I completely understand. I did reach out and say, hey, there was an add-on case and can we get a CR number? But I know Mr. Jordan was out yesterday. So Mr. M didn't actually handle that for me. I can send, Your Honor, a recommendation, a revised recommendation, given this additional information into Ms. Vigiletti so she can talk to her client.
Okay, do you just tell us what's the recommendation for the add-on case, and then we'll take then y'all can deal with it down the this calendar, or we can pick it up on Thursday. So
Your Honor, the state's recommendation is actually not going to change. So our recommendation is still going to be 12 months, serve 60 days, credit for time served 15 days, balance probated, anti-theft course, and we're asking for 2 stayaways. There's actually a stay away from Binky's, which is a restaurant, and then stay away from the Marriott Hotel at 239 Ivan Allen Jr. Boulevard. So that is just going to run concurrent.
Was it Pinky or Binky?
Binky's.
Okay.
BINKY''S.
Okay. All right, Ms. Vigiletti, that is the recommendation. If you want to contact jail court iPhone or be placed in a breakout, we'll be glad to accommodate that. Meanwhile, Mr. McLean, Miss Grace, if you could place Mr. McLean and medical in a breakout session, please.
Yes, ma'am.
Mr. McLean, you're going to see a message for a breakout session. Medical, you're going to see a message on your screen for a breakout session. And Ms. Vigiletti, would you like a breakout from the courtroom, or do you have your own device to put you in a breakout?
I have my own device, Judge. I'm logging in right now to Zoom.
Right. No, Sean, the answer is no. All right. All right. Now, so I'm sorry, am I going to put you in a breakout from courtroom 2 or your own device?
I'm logging into Zoom with my own device. I'm having some trouble. Ever since I updated my computer, I've had some Zoom trouble. So I'm just trying to log in. Okay, here we are. I will say, Judge, both of these, all of the clients left in the courtroom are mine. So perhaps we could move forward with those, and then there will be no one in the courtroom, and I could speak very quickly with Mr. Woodard.
Jail court iPhone, will you be able to hold for about 10 minutes?
Yes.
All right, thank you. Please mute jail court iPhone. All right, your next client, Ms. Vigiletti?
Yes, Judge, this is from the probation calendar, Mr. Diaz Moody, positions 9 and 10.
All right. Miss Officer Brooks? Okay, 9 and 10. Diaz Dentrell Moody is a probation revocation matter, 21 CR 1870E. Mr. Moody was convicted of a PI offense. Mr. Moody, you've been advised of your right to remain silent, and your attorney is Miss Vigiletti. Miss Vigiletti, have you shared the offense of which he was convicted?
I'm sorry?
Have you shared with him the information?
Yes,
of the
yes, yes.
offense?
Talked
Okay.
about his
Yeah.
yes.
Okay, and Mr. Moody's probation revocation case is 24 PV 315. Officer Brooks, you're still under oath. When was this conviction?
Yes, Your Honor, thank you. It was on December 22nd of 2022 for public indecency.
Normally, we
seen-
just refer to it as PI, but we don't
I'm
sound it
sorry.
out. Okay, that's okay. And what has he not done?
He never reported, Your Honor, and he didn't complete the class.
Is that an SDET class?
Yes,
Okay. And has probation ever heard from him? Text
No.
messages or phone calls? Okay.
no.
All right, and what's the recommendation?
To continue on probation.
How many more days?
55.
55 days. Okay. Miss Vigiletti?
Yes, Judge. I spoke with Mr. Moody this morning. He has been incarcerated for several months, over 10 months. He was in Augusta for about 4 months, and then Augusta released him to LaGrange for about 7 months, and LaGrange released him to Fulton. And because I just met Mr. Moody this morning, I don't have proof of incarceration that I can provide right now, but I could reach out to those jurisdictions and get proof of incarceration today.
So are you asking for this case to be reset?
Well, because they want to put him back on probation, I don't want to hold him in the jail if we don't have to. That is the reason he did report, is for being incarcerated.
He's been in custody now for 13 days. He'll be given credit for 26 days. Which means he has 2 more weeks to serve at the Fulton County Jail and the case will be closed. So if you want to confer with him about that option, that's also available. Either way, it's going to be marked as a probation violation.
Okay. One moment, Judge.
All right.
Ms. Falk, can you check your chat, please?
I'll make this really bad at it.
Yes, ma'am, checking now.
Miss. Okay. All right. Medical, have you completed your breakout with Mr. McLean?
We have completed the breakout session.
Okay. Ms. Vigiletti, may I address Mr. McLean while you speak to your client? All right, Mr. McLean, what is?
Your Honor, he is going to make a decision to defer any research into legal issues to the future. And for now, he certainly understands that barring any research that shows that his probation is over with, then he's still going to do his best.
We're going to defer any research. In other words, we don't know whether the Clayton County matter involves this probation warrant or not.
We would have to have somebody get hold of certified or very reliable Clayton records. And we're willing to do that, but that would cause a delay in his release. The better solution for him is to assume that maybe he's wrong. And in a very polite and respectful way, if he's right, he can show that later, but he really would like to be out now. And getting out now means that he's accepting the idea that he's going to assume that his probation is continuing and that he's still under obligation to do that class.
Mr. Flowers, please unmute medical.
Yes,
Mr.
ma'am.
Flowers, right now, I'm going to make a decision as to whether you are going to have to complete 277 days of probation or, and if I make that decision right now, that's not going to change, no matter how long you spent in Clayton County.
All right.
I'm not changing that time.
Yes, ma'am.
So if you come back from Clayton County and said, look, I spent so long in Clayton County, it's not going to change the time that you're going to be on probation.
All right.
There's going to be no corrections if I make that decision today.
Okay.
Otherwise, I can reset the case and your attorney can get the information and we can revisit your time served if that applies. What would you like to do?
I would like to reinstate my probation and get out.
And you understand you have 277 days left.
Yes, ma'am.
Not a single day less.
Correct. Yes, ma'am.
I'm going to record Mr. Flowers' case as a probation violation. He is going to continue on probation. He must report to probation on Thursday, this Thursday. Today is Tuesday. You report to probation day after tomorrow, on Thursday before 3 p.m. You must report at 132 Mitchell Street in downtown Atlanta. Between now and then, if you get arrested again, or if you ever get arrested again in the future, you must contact your probation officer because clearly you do know how to communicate with them. Do you understand?
Yes, ma'am.
All right. You are going to report to probation twice a month. Not once, twice a month. And you will continue reporting twice a month until you have completed your anger management classes. After you've completed the anger management classes, then you may report once a month. Do you understand?
Yes, ma'am.
If you fail to report, if you don't start on the classes, you can then spend the rest of the 277 days left on your probation or whatever is left of it in jail. It's that simple.
All right.
You must begin your classes within 30 days of being released.
Okay.
Now you need to let me know if this is not doable, because if you cannot complete this, then let me know and we can have you serve out the rest of the 277 days in jail.
No, I don't want to sit in nobody jail. It's doable.
Okay. That's on record. This is a probation violation and he's going to continue on probation. Ms. Brooks, Officer Brooks, any questions about his continuing time?
No, Your Honor.
Okay, twice a month until he's done with all anger management classes. Thank you. All right, medical. Ms. Vigiletti, are we ready to address your client?
Yes, Judge.
And so he has 55 days left. What would he like to do? Serve out the rest of the time, or would he like to continue on probation?
Mr. Moody would like to continue on probation.
Okay. What's that? The state, so he has 55 days left. Okay. So the likelihood of getting an SDET is very, very small. These classes are few and far in between. And Mr. Moody has failed to complete those classes, and he has failed to report to probation. He will report to probation every week, once a week. He will complete 60 hours of voluntary community service, an average of 10 hours per week, in lieu of the SDET class. Mr. Moody, do you understand? Because you failed to report, because you failed to complete your class, because you failed to even let anyone know, and you've not completed the sentence that was imposed upon you, you're required to do 60 hours of voluntary community service at any nonprofit agency that is not a church and a school. Every week that you report to probation, you must bring a letter from the community service agency showing that you completed at least 10 hours. Do you understand?
Yes.
If you fail to do so, probation is authorized to revoke your probation and have you serve out the rest of the time in jail.
All right, excuse me, Judge, if I could prove that I was incarcerated during this time, will that change anything?
Not today, but if you want to have that proof, I can reset this case for you to
No,
get.
ma'am,
the
I
proof.
want to go ahead with, what's going on right now.
All right. So, Officer Brooks, he will continue on probation. He will report to probation this Thursday before 3 p.m. at 132 Mitchell Street, downtown Atlanta. He will report to probation once a week. He is to complete at least 10 hours of voluntary community service, with the last week in which he would have to complete 15 hours in order to 10, 20, 30. Yeah. The last week would have to do at least 20 hours to make sure he completes all 60 hours of voluntary community service. Any questions, Mr. Moody?
No.
All right, thank you.
Position number 24, Mr. Lewis.
Thank you.
Ma'am. 24. And is Lewis at medical?
Yes, ma'am.
Oh. Mr. McLean, that is your client, and this is going to be a negotiated plea.
That's correct, Your Honor.
This is State versus Mario Lewis, accused of, I'm so sorry. Yeah, accused of theft by shoplifting and giving false information to a law enforcement officer. Case number 24 CR 922. Incident date is February 24th, 2024. Mr. Lewis, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Do you see your attorney on the screen? Mr. McLean?
Yes, ma'am, I do.
All right, good. This is going to be a negotiated plea. May I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Okay.
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. The state's recommendation is 12 months probation, serve 30 days, credit for time served 18 days. That's going to be from February 24th to March 12th of 2024. Balance is probated. Anti-theft course, stay away from Walmart located at 844 Cleveland Avenue Southwest in East Point, and 40 hours of community service. Count 2, the giving false name, we are requesting 12 months probation to run concurrent with count 1. I will ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And just to put on the record, it looks like the defendant has 34 cycles, and he does have previous thefts, but I do not believe any of his thefts are theft by shoplifting. And so this is he has, one prior theft by shoplifting in 2017, and I'm not sure there is another arrest for theft by shoplifting, but I don't show a disposition. That's all for the state.
Thank you.
For the purpose, we do so stipulate.
All right, thank you. Mr. Lewis, have you consumed any medicine or alcohol?
No, ma'am, I have.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Understand that if you do so, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court with your attorney, challenge the evidence brought against you, confront your accuser, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I understand.
How do you plead to theft by shoplifting and giving false information to an officer?
Guilty.
Repeat.
Guilty.
On count one, your sentence is 12 months to serve 30 days, credit for time served 18 days. Your jail time is concluded. You will report to probation next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service, which you must begin within 30 days of being released. You must complete at least 5 hours of community service a month. You're also to complete an anti-theft class, and you must begin that class within 30 days of being released, and you must show proof of enrollment by your second probation visit. You cannot return to the Walmart located at 844 Cleveland Avenue in East Point, Georgia. Count two, your sentence is 12 months to serve concurrent to count one. Thank you.
Yes, ma'am.
All right, Mr. McLean, have you spoken to your client at Jail Court iPhone?
Did we determine who that is there? We have several, and I'm not sure.
Tiffany? Wasn't that Mr. McLean's client? Jail Court iPhone, are we ready?
Yes, we're ready.
All right, and that was position number?
44 and 45.
That's right.
Well, that'll be Miss Vigilante, I believe.
Oh, okay.
44 or 5? 44.
Okay, are we ready to go into a breakout room with Mr. Woodard?
Or you were waiting to go into a breakout room with 44 and 45?
Yes, I'm sorry. I've gotten a little sidetracked here. I was working with people in the courtroom and
Okay.
with the plan. I'm
Do
sorry.
you
I'm
have,
having
do you
trouble
have a
with-
device that can put you into a breakout?
Yeah, I'm gonna use PD Abden's computer because my Zoom is not interested.
Okay, no problem. Miss Grace, Miss Abden, we're gonna put Miss Vigilante through your device in a breakout session. You might see a message there. Miss Grace, can we put Jail Court iPhone in a breakout, please?
Yes,
With,
ma'am.
The panel, Rachel Abden. Thank you.
Okay.
Mr. McLean, do you have any other clients in courtroom 2?
Oh, no, Your Honor.
Do you have any clients at Fulton ACDC?
Miss Lurie, who is number 25. Miss Stones, number 34. Quinetta Jones, number 22.
Okay. Deputy Milton at Fulton ACDC?
Good morning, Your Honor. This is position 25, Miss Lurie.
All right. All right. Good morning, ladies at Fulton ACDC. My name is Judge Law, and I'd just like to remind you that we are addressing your misdemeanor cases. Please remember to remain silent, exercise your right to remain silent. Anything you say about the facts or circumstances of your case, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. This is State versus Charlicia Lurie, case number 24 CR 1017E, accused of loitering and prowling. Ms. Lurie, you've been advised of your right to remain silent, and your attorney is Mr. McLean. If you could please sit up straight, I need to be able to see you. Thank you. Mr. McLean, this is a non-negotiated plea, from what I gather.
Yes, Your Honor. I don't know of any way to alert B130DL iPhone or telephone.
I'll do that. But in the meantime, do you have, is it a non-negotiated plea?
It is.
All right. The young lady who appeared on phone, B130DL.
Young man, I believe one.
Oh, was it a gentleman? Okay. B130DL, could you please unmute and start your video? Okay. Ms. Lurie, we're going to address your plea. We're first going to hear from the prosecutor, and then I will hear the recommendation from your attorney. I will let you know which recommendation I'm going to accept. And if you still want to move forward with the plea hearing, then we will do so. Ms. Falk?
Yes, Your Honor. This incident happened May 5th, 2024 at around, let's see, 11:43 p.m. Officers were dispatched to Alpharetta Highway, Nally Toyota, in reference to someone entering the vehicles at that location. They were monitoring the cameras and saw the defendant walking around the property. There were 7 vehicles with hazards on and doors open. The key holder was called to the scene, looked and saw if anything was missing. He said none of the vehicles had anything missing except for a red Toyota Tundra, which had a charge kit that was missing and a navigation SD card from a white Porsche. There was also another business, Gravity Autos, that had someone come on the premises and enter the vehicles. 2 vehicles had been entered in that, and nothing seemed to be missing. A third vehicle, a third location was also contacted, Enterprise Enterprise Auto, and they had 2 white transit vans that had the hazard on and the doors were closed and they appear to have been opened, as well as a green Jeep Rubicon at Palmer Dodge Chrysler Jeep Ram in Roswell. The security team observed the defendant entering the vehicles at Nally Toyota. They were able to give the officers a good description. That description matched the defendant, who is located at the racetrack off Hembry Road. They went and spoke with her and made contact with the defendant, who admitted she entered the vehicles because she was curious. While talking to her, they also found she was holding an owner's manual for a Jeep, one of the vehicles that was entered at Palmer Dodge Chrysler Jeep Ram in Roswell. So the defendant was then taken into custody. Warrants were issued for her. Actually, multiple counts of entering auto warrants were issued. This case, for whatever reason, was transferred down to the solicitor's office, and that is how we came to have this case as a loitering and prowling. It was all the entering auto charges were dismissed, and it was transferred down as an entering auto, as a loitering and prowling. I will say that looking at her history is quite long, and as she is a multi-state offender, she actually has 2 cycles out of South Carolina. The most recent one was 2020, unlawful neglect of a child, which was an arrest that does not show a disposition. Previous to that, 2016 conviction for public disorderly. She also has several cycles in Florida. I believe she has, just going through her history, she has 17 cycles in Florida. The most recent charge was for an arrest in March of 2023 for grand theft of motor vehicle. Those charges were dropped. She also had a 2022 arrest for trespassing. That was null prost in 2022. She also had a 2022 trespassing conviction where she was convicted of that charge on, it looks like, March 11th of 2022. She was convicted. And then beyond that, she had a burglary with assault battery arrest. It looks like the adjudication was withheld on that, and that was April of 2010. For that, she received 3 years probation with 198 days credit for time served. Moving on to her Georgia history, she has, let's see, I believe it is 8 prior arrests in Georgia. She looks like she was convicted of simple battery in Henry County in 2013, received 12 months probation. She had a local ordinance charge in 2018 for marijuana possession. She has a probation violation in 2018 where she was found guilty of probation violation, and in 2019 out of Gwinnett, and has a theft by taking from July 31st of 2023 out of Alpharetta Police Department. I'm not showing a disposition on that charge. And then the multiple entering autos, which were resolved by transfer down to our office. So the state's recommendation based on her history, especially because it does contain a lot of theft allegations and arrests, was 12 months serve 100 days, credit for time served 36 days. That's going to be from February 6th, 2024 to March 12th of 2024. Ballots probated. Stay away from Enterprise at 10889 Alpharetta Highway, Nally Toyota at 11130 Alpharetta Highway, Gravity Auto at 11170 Alpharetta Highway, and we will add to that, stay away from the Palmer Dodge Chrysler Jeep Ram on Alpharetta Highway. So that is all for the state. We would like to ask the defense to stipulate to venue, factual basis, and identification for the purposes of this non-negotiated plea.
For the purposes of the plea, we do so stipulate.
All right, Mr. McLean, what would you recommend?
Your Honor, because the case was reduced to loitering and prowling, we feel that a more tailored sentence providing punishment and providing the elements of rehabilitation that can go along with punishment would be better reflected in 12 months to serve the double the number of days she has served. That would be 12 months to serve 72 days, credit for 36. Then she would be released on probation now instead of the anti-theft course and MHET and whatever community service would be tailored to imitate or substitute for the 14 extra days the state was looking for. 14 extra days is a fortnight, basically that's 2 weeks. So 80 hours of community service would represent 2 full-time weeks of work. Something like that.
Just 1 second. I'm just looking at her, just the Fulton County. She's got an open felony case, 23 CP 220645 for theft by taking from March 12th of 2023.
Also, I think the state started off saying this was in May of 2024, but that hasn't occurred yet. I think the state meant to say February.
So while she's on a bond, UJR bond from the felony case, she incurs this new case in less than 1 year. I'm going to go with the state's recommendation. Ms. Lurie clearly has a significant criminal record history. Before I move forward, this gentleman with a hat at B13ODL, did you want to address the court?
Let me do a breakout room with ACDC and see what she wants to do.
All right, Ms. Lurie, if you could, would you like an opportunity to speak with your attorney?
Yes, that
Okay.
was,
Then please step to the side and I'll take the next case
Thank you.
with Mr.
So we do
McLean.
probation 1 and 2,
Mr.
and medical probation 1 and 2, medical.
Okay, all right, Deputy
open
Milton?
case was dropped.
No, Ms. Lurie, is active and open.
Yeah, that was dropped in Florida.
No, your Fulton County case is open. You're gonna speak to your attorney about this.
So Judge, you want me to put ACDC and Mr. McLean in a breakout?
Let me see if Mr. McLean is addressing this probation revocation matter.
Okay, just let me know.
All right, Mr. McLean, who has medical probation revocation 1 and 2?
Mr. McLean, and he has stepped out.
You're next.
But I'm prepared to move forward with Mr. Woodard. If we could move to position 44 and 45.
Okay. 44, 45, that's Mr. Woodard. And he's the one at the jail court iPhone?
Yes, Judge.
And how are we proceeding?
We have discussed the updated recommendation from Ms. Falk, and Mr. Woodard would like to enter the plea as negotiated.
Okay, Mr. McLean, we're gonna put you in a breakout. Deputy Milton, if you could put the breakout session with Fulton ACDC and Ms. Grace with Mr. McLean. Mr. McLean, you're gonna see a message on the screen to join a breakout.
Thank you, Your Honor.
Mhm. And Deputy Milton, please make sure that you join the breakout too. The person who's an iPhone, the young lady in a white t-shirt, could you please stop your video until your case comes forward? Yeah, thank you. All right, Ms. Strong, are you ready to move forward with the paperwork on the additional case?
Yes, ma'am.
Okay. This is Jarvis Woodard. As Ms. Falk has indicated, he's got an additional case of 24 CR 001138J, theft by taking from May 4th, 2023, with regards to a restaurant called Binky's. In addition to his case 24 CR 7J, in which he's accused of theft by taking from December 30th, 2023, allegedly from the Marriott Hotel on Ivan Allen Jr. Boulevard. Mr. Woodard, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Mr. Woodard, please raise your right hand. For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Ms. Falk?
And yes, Your Honor, just to correct something for the record, that's actually how this case came to our attention, is the incident on December 30th of 2023 that is on the calendar is the one that happened at Binky's, and the new case, the 24 CR 001138J case, is the incident that happened at the Spring Hill Suites Marriott. And so that's actually how we realized there was an accused case that was standing out there. So the state's recommendation on this current case on the calendar, the theft by taking misdemeanor, is 12 months with 60 days to serve, credit for time served 15 days. That's going to be from December 31st, 2023 to January 3rd, 2024, and then March 2nd to March 12th of 2024. The balance will be probated. There will be an anti-theft course, and we are asking for stay away from Binky's Eatery located at 20 Broad Street Southwest in Atlanta. On the second case, that was the add-on on the calendar, 24 CR 001138J, that first count of theft by taking is 12 months probation concurrent with count 1. Stay away from the Spring Hill Suites Marriott Hotel located at 239 Ivan Allen Jr. Boulevard in Atlanta, Georgia. Count 2, the obstruction of law enforcement officer. The state's recommendation is 12 months probation concurrent with count 1. The state would ask that the probation not terminate or go to non-reporting on these cases, since there are 2 cases involved. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of the plea, and that is all for the state.
Ms. Vigiletti?
Yes, so stipulated. As I said, Mr. Woodard is prepared to enter the plea as negotiated, so we would just ask the court to accept the recommendation of the state today. One request that I have, because Mr. Woodard has been struggling with housing and income, if it's possible for the court to waive some of his probation fees to give him a chance to get back on his feet.
I'll waive the probation fees for March and April. will need to get a job and get started on May 1st onwards.
Okay, thank you,
And
Judge.
start on paying probation fees from May 1st onwards. His probation begins as soon as he's sentenced. All right. Mr. Woodard? Have you consumed any medicine or alcohol?
Ma'am?
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on?
Yes, Your Honor, I do, ma'am.
Do you understand that you'll be pleading guilty to 2 counts of theft by taking from 2 separate cases at 2 separate locations?
Yes, ma'am.
And you understand that you'll be on probation every month?
Yes, ma'am.
Is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And are you satisfied with your legal services?
Yes, ma'am. I'm satisfied, ma'am.
If you decide to plead guilty to these 2 cases, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to have an attorney to go back to court, to confront your accuser, challenge the evidence brought before you, present your own defenses and arguments, and also have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Are you entering a plea to both cases freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to theft by taking from December 30th, 2023 at Binky's Restaurant?
I'm guilty, ma'am. I plead guilty.
How do you plead to 1 count of theft by taking and willful obstruction of an officer from May 4th, 2023 at the Spring Hill Suites by Marriott?
I plead guilty, ma'am. I plead guilty.
Your sentence for theft by taking in 24 CR number 7J is 12 months to serve 60 days, credit for time served 15 days, which means that you have 15 more days to serve out at the jail before you may be released. Once you're released, you are to report to probation at the first available business day. Your probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll in an anti-theft class. You must enroll in that class within 90 days of being released. You're not to return to the Binky's Restaurant at all. On the second the second charge of theft by taking, your sentence will be 12 months probation, concurrent with the one of which you've just been convicted, and you have to stay away from the Spring Hill Suites by Marriott at 239 Ivan Allen Jr. Boulevard in Atlanta, Georgia. Your sentence on the willful obstruction of an officer will be 12 months probation concurrent to count 1. No illegal drugs, no alcohol, no weapons, and no firearms. Thank you.
Yes, ma'am.
And the bench warrant is null pros, position 45.
I apologize. What was the plea on the added case?
It was a guilty plea to theft by taking and willful obstruction of an officer.
What was the time? I'm sorry.
12 months probation concurrent to count 1 of the first case.
Oh, okay. All right. Thank you.
Position 42 and 43, medical.
Ms. Vigilante, is that your client?
Yes, Judge, this is Rakima Walker. Who would like to enter a plea?
State versus Rakima Walker, position 42 and 43. Case is 23 CR 8074E. Mr. Walker is accused of criminal trespass, battery, and willful obstruction of an officer from December 17th, 2023. He's got a bench warrant matter on position 43, 24 FTA 225. Mr. Walker, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigilante. This is due to be a negotiated plea, Ms. Vigilante?
Yes, Judge.
All right. Mr. Walker, please raise your right hand. For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Paul?
Yes, Your Honor. On count one, the criminal trespass, the state's recommendation is 12 months concurrent to count two. Excuse me. Count two, the battery is 12 months probation, serve 32 days, credit for time served 16 days. That's going to be from December 18th, 2023 to December 20th of 2023, February 29th of 2024 to March 12th of 2024. Balance probated, stay away from 2424 Piedmont Road Northeast, Atlanta, Georgia, which is MARTA. 8 weeks anger management. Count three will merge with count two. And so that's just going to be a total of 12 months probation, serve 32 days, credit for time served 16, balance probated, stay away from 2424 Piedmont Road Northeast, Atlanta, Georgia, which is the MARTA station, 8 weeks of anger management. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
So stipulated.
Mr. Walker, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood the proceeding so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, Your Honor.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to enter this guilty plea, you would have to give up your constitutional right to challenge these charges in a court of law. You will not have the opportunity to have an attorney to confront your accuser, challenge the evidence brought before you, present any defenses and arguments, and have the state try to prove the charges against you beyond a doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass, battery,
Yep.
and willful obstruction of a law enforcement officer?
Guilty.
You understand that you'll have to stay away from MARTA for up to 1 year. Do you understand?
Yes, ma'am.
All right. Your sentences on counts 1 and count 3 are going to be concurrent to count 2. The sentence on count 2, battery, is going to be 12 months probation to serve 32 days. 12 months to serve 32 days. Credit for time served 16 days. If you have no other holds, you'll be released, and you must report to probation next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 8 anger management classes, which you must begin within 30 days of being released. You must also stay away from MARTA property, all MARTA property, for the time that you're on probation, not just the one at Piedmont Road. Do you understand?
Yes, ma'am.
Your next, I think that concludes the plea. Thank you.
I'm sorry, Judge, very quickly, would you consider a non-reporting status upon completion of anger management?
This is a battery offense at a public transit station. No,
Okay, understood.
he must report every month.
Do I have a warrant?
I'm sorry?
Do I have a bench warrant out?
Yes, you do have a bench warrant, and that's going to be closed out. Thank you for that. Yeah.
Okay.
That's
Thank
going to
you.
be all crossed. Thank you.
And Your Honor, just to put on the record, count 3 is going to merge with count 2. So it's not a run concurrent because it's alleging the same
Oh,
offense.
you're right. That was so Ms. Strong, I do apologize. Count 1, criminal trespass, is concurrent. Count 3 is merged with count 2. Thank you. All right.
Next we have positions 2 and 3. Mr. Bell,
Could you repeat that number again?
positions 2 and 3.
2 and 3. Okay. Is Mr. McLean available?
He is.
Okay. Mr. Bell, I'll be with you very shortly.
Yes, ma'am.
Mr. McLean, how are we moving forward with Ms. Lurie's case?
We're moving forward with the plea.
All right, she understands that she has additional time to serve at the jail.
14 additional days, I believe it is, Your Honor, followed by probation with the anti-theft class.
All right. Deputy Milton, please unmute Fulton ACDC. All right. So as I was saying, Mr. McLean, I'm going to accept the state's recommendation And she needs to understand that she will be on probation to complete these items. She did mention, I want to make sure she understands that her felony case in Fulton County, Georgia is still open and active.
I told her how to contact people on that.
All right. So, Ms. Lurie, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I can't hear you.
Yes,
Okay. Have you consumed any medicine or alcohol?
no,
And have you understood what's been going on in your case so far?
yes. I'm confused, but yes, okay.
Then I won't take your plea. I'll reset your case until you're not confused. If you need to
No,
have a further
that's-
conversation with your attorney, then I'll be glad to address it. But
I
I'm not
accept
going to
the plea.
but I'm not going to address a confused person.
I accept it.
No. What do you
Please.
not understand?
You said the open case. That was just the only thing I just,
That's got nothing to do with today.
so I accept what's going on today.
Well, part of what's going on today is that while you're on probation, you still have an active felony case against you in Fulton County, Georgia. It has not been dismissed. There is no dismissal. I just looked it up.
Again, I said I accept the case for today, but I'm still not understanding that.
Right, she'll come to our office and speak with them about representation.
Okay. All right. And Ms. Lurie, are you satisfied with your legal services so far?
Yes,
And if you decide to enter into this plea offer, you understand that you'll be on active probation after you have served additional jail time. Are you still willing to move forward?
yes,
Is anybody forcing you to take this plea today?
no,
And do you understand that if you decide to plead guilty to this offense, you would have to give up your constitutional right to challenge this charge in a court of law in front of a judge or a jury? You will not have the assistance of counsel to confront your accuser, challenge the evidence brought before you, present any defenses, arguments, and mitigating factors if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes. What is the charge?
No, she's talking about today's case.
Yes,
Are you pleading guilty to loitering or prowling? That's the charge.
yes,
How do you plead to one count of loitering and prowling from February 5th, 2024?
guilty. You said guilty. You said,
What?
how do I plead?
What question do you have about this charge?
I don't have any question.
So do you know what the charge is against you?
You just said loitering.
I didn't say anything. I'm asking you, what is the charge brought against you?
Loitering,
And what location?
the Gravity Auto and Enterprise.
Okay, so I'm going to ask you again. How do you plead to one count of loitering and prowling?
Guilty.
Your sentence is 12 months to serve 100 days, credit for time served 36 days. You do have additional time that you would have to serve at the Fulton County Jail. Once you have served this additional time, you will then be released to report to probation. You must report to probation in Fulton County by the first available business day, which will be a Monday, a Tuesday, or a Thursday. You must report before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete an anti-theft course and you must enroll in that program within 30 days of being released. At all times, you are to stay away from the Nally Toyota store at 11130 Alpharetta Highway and the Gravity Auto store at 11170 Alpharetta Highway, both in Alpharetta, Georgia. You must report to probation every month for the remainder of your time left on the sentence. And if you fail to complete the class, or if you fail to report, or if you get arrested again, probation is authorized to file a warrant to revoke your probation and complete the rest of the time in prison. Do you understand?
Okay.
Thank you. Positions 2 and 3, we have Edward Bell. Case number 22 CR 5820D. Mr. Bell was accused of DUI, driving under the influence of alcohol less safe, failure to maintain lane or improper lane change, obstruction of a law enforcement officer, and reckless driving, stemming from a traffic incident of January 16th, 2021. Position 3 is a bench warrant under 24 FTA 228. Mr. Bell, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. All right, Mr. Bell, if you please raise your right hand. For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation for Mr. Bell?
Yes, Your Honor. The state's recommendation on count 1 is 12 months served, 20 days, credit for time served, 10 days. That's from March 3rd of 2024 till today. Balance probated, a $300 fine, 40 hours of community service, DUI risk reduction, victim impact panel, and alcohol drug evaluation and treatment. Count 2, the failure to maintain lane, is going to be 12 months concurrent with count 1 with a $265 fine. Count 3, the obstruction of law enforcement officer, will be 12 months concurrent with count 1 with a $300 fine. And count 4, the reckless driving, will be 12 months with consecutive to count 1 with a $500 fine. So that will be a total of 24 months, serve 20 days, credit for time served 10 days, balance probated, $1,365 in fines, 40 hours of community service, DUI risk reduction, victim impact panel, and alcohol drug evaluation and treatment. That is all for the state. We would ask the defense to stipulate to venue factual basis and identification for the purposes of this plea.
So stipulated.
Mr. David Smith? Mr. David Smith, are you involved in this case? David Smith, are you involved in this case?
This is, I'm sorry, this is Mr. Bell.
Yeah, I know. Mr. David Smith, if you're not involved in this case, stop your video. It's very distracting when you walk around. Stop your video. Thank you. Oh, I'm sorry about that, Mr. Bell. I was trying to address somebody else who was walking around.
Okay.
Mr. Edward Bell, I'm sorry, Ms. Vigiletti, you've already so stipulated. Mr. Bell, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to enter a guilty plea, you know that this is going to add points to your driving history.
Yes, ma'am.
And if you decide to plead guilty to DUI, that is going to trigger a license suspension for 1 year.
Yes, ma'am.
So you understand that you will not be driving for 1 year.
Yes, ma'am.
Okay. If you decide to also plead guilty to these charges, you would have to give up your constitutional right to challenge them in a court of law and during a trial in front of a judge or a jury. You will not have the assistance of counsel to confront your accuser, to challenge the evidence brought before you, present any defenses, arguments, and mitigating factors, as well as have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of driving under the influence of alcohol less safe, failure to maintain lane or improper lane change, obstruction of a law enforcement officer, and reckless driving?
Guilty.
Count 1 On the DUI, your sentence is 12 months to serve 20 days, credit for time served 10 days. The balance will be on probation. If you have no other holds at the Fulton County Jail or any other location, you will report to probation next Tuesday, March 19th, before 3 p.m. The report location is 132 Mitchell Street in downtown Atlanta.
Yes, ma'am.
While on probation for DUI, you will pay a $300 fine, complete 40 hours of voluntary community service, attend and complete a risk reduction program, attend and complete a victim impact class, and submit to an alcohol and drug evaluation. The 40 hours of community service must begin within 30 days of being released, and you must do at least 5 hours a month. The risk reduction class, the alcohol, drug evaluation, and the victim impact must be completed within 180 days of being released. You must report to probation every month, and you are not to consume any alcohol and no illegal drugs. You will be subject to random screens. You are also not authorized to drive for 1 year pursuant to your license suspension. And with regards to count 2, the failure to maintain lane change, your sentence is 12 months probation concurrent to count 1 with an additional $265 fine. With regards to obstruction of a law enforcement officer, is 12 months probation concurrent to count 1 with an additional $300 fine. With regards to count 4, reckless driving, that's going to be 12 months probation consecutive to count 1, which means that you will be on probation for an additional 12 months with a $500 fine. That's in addition to the fines I've just listed. That concludes your sentence. Any questions, Mr. Bell?
Yes, ma'am.
All right.
During the time when I caught the case, when they tried to, they suspended my license the same day when I got arrested. I was wondering, like, since I had already had my license suspended for a year, then would that count for anything to now, or it's just gonna be 2 years of suspended license?
When you got arrested for DUI,
Yes, ma'am.
and if you did not appeal the license suspension,
Yes,
then
ma'am.
your license will be suspended for 1 year.
Okay, I just want, okay.
That is totally separate from this conviction.
Yes, ma'am.
This
Yes, ma'am.
conviction, your license is suspended for 1 year.
Yes, ma'am.
The second, the additional 24 months of probation is for reckless driving.
Yes, ma'am.
And so during that second time, you can apply to get your license reinstated.
Okay. Thank you.
However, if you have 12 or more points on your driving history in your last 12 months, that can trigger another license suspension. So do not drive until you get the green light and the blessing of the Department of Driver Services.
Yes, ma'am.
All right, thank you.
Probation 1 and 2, medical.
Mr. Bell's bench warrant is null pros, position number 3. Okay. Probation 1 and 2, Jerry Dixon at medical. Mr.
Yes,
Jerry
Your Honor.
Dixon, you've got a probation revocation matter 22 CR 3876Y, in which you were convicted of criminal trespass. And you've got a probation violation case 24 PV 313. Mr. Dixon, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean will be representing you. Mr. McLean, your client's at medical, correct?
That's correct, Your Honor.
All right. Officer Brooks, when was Mr. Dixon convicted?
Back on August the 17th of 2023.
All right. And why are you all seeking a warrant? I mean, a revocation, and what's your recommendation?
Yes, Your Honor. He was sentenced to complete 50 hours of community service and do 12 months on probation. He never reported to probation and he did not complete the 50 hours of community service. And we are asking that he have time served.
Do you know how much time he had left on his probation?
Yes, 290 days.
All right. Mr. McLean?
I believe Mr. Dixon would like to accept that recommendation. Is that correct, Mr. Dixon?
Yes.
Thank you.
And I need to put on the disposition how much time he's already been at Fulton County Jail, so I can commute that to time served.
He
Miss-
was arrested on February 29th.
So that will be 12 days, 13 days today?
13 days.
All right. I will accept the state's recommendation. This is going to be a probation violation recorded on his record. I will accept the time that he served and commute the time that he served and close out the case. Thank you.
Thank you.
26 days.
Next, we have position number 39 and 41.
39 and 41, and that's going to be Mr. McLean's case. Oh. Oh, that's Miss Vigiletti. Miss Vigiletti?
Yes, this is Mr. Colby Walding.
Okay.
And I believe one of his cases, we're waiting to see if it might be transferred to the DA's office, but we are prepared to accept a negotiated plea today on the other two cases.
And Your Honor, my announcement on that is I did have to send the DA's office some additional information, including the fact that the officer in position 39 had a fractured nasal passage as a result of the incident with Mr. Walding, and I am awaiting their response to that information. But I did have a chance to speak to Mr. Hammonds, who is the victim on position 39, who indicated that he did have a fractured nasal passage and he is still receiving treatment for that and by a specialist, which would easily qualify for felony obstruction since he was a corrections officer at the time of the incident.
All right, and is there a bond on that particular case, position 39?
No, that's actually the charge. I mean, well, that's actually the charge that is holding him in jail currently.
He's got a 2,500 signature bond through the jail.
Well, we're actually showing a $3,000 surety bond since he was rearrested on that charge for failure to appear.
Oh, I'm sorry, maybe I pulled up the wrong one. Colby Walden. $39. Check.
And actually, my apologies, it wasn't a failure to appear. It was a pretrial bond surrender that was done by pretrial services on January 16th of 2024.
Okay. All right. Miss Vigiletti, is that your understanding that Mr. Colby currently has a $3,000 surety bond?
Yes,
He
Judge.
went to the surrender of the pretrial bond?
Yes, that is also what I see on the simple battery, which will be upgraded, it sounds like.
All right. This is State versus Colby Aaron Walding. On position 40, case number is 24 CR 337A. Charged with criminal trespass from November 27, 2023 at Georgia Tech property. And position 41 is 24 CR 338A, accused of theft by taking from January 11th, 2024. Mr. Walding, these are the two open cases that we are addressing for this negotiated plea matter. You've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
I can't hear you.
Yes, ma'am.
Thank you. All right, Ms. Falk, what's the recommendation for these two cases?
Your Honor, on position 40, the state's recommendation is 12 months probation, serve 4 days, credit for time served 2 days. That's from January 12th to January 13th. Balance probated, that's going to run concurrent with position 41. Stay away from all Georgia Tech property. On position 41, the theft by taking 12 months to probation, serve 4 days, credit for time served 2 days, balance probated, stay away from all Georgia Tech property, take an anti-theft course, and 40 hours of community service. That is a global recommendation. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
I'm so sorry. I must have missed something. I only have half of this recommendation written down, so I have only gone over half of it with him. And I'm sure you wrote it right. I must have missed something here.
Go ahead and mute your screen and complete that.
Okay, I see. Yes, I looked at this first criminal trespass, and I didn't see that the second one had other requirements. Okay, yes, we need to speak for just a moment. I was in the suite number.
Yes, Ms. Vigilant?
Yes, Judge, we have discussed the plea offer, and Mr. Walding would like to enter the plea as negotiated today.
All right. Mr. Walding, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood your what's been going on so far in all your 3 cases?
Yes, ma'am.
And you understand that you're pleading guilty to 2 of the 3 cases?
Yes, ma'am.
Are you satisfied with your legal services?
I was wondering about if I have a hold from Mississippi, I'm from Mississippi originally. Is there a way I could be transported back to Mississippi?
Only if you pay the $3,000 bond on the other case.
Judge,
Yes, ma'am.
we also discussed needing to request from the probation officer to transfer probation if he wants to move.
Only if he makes that $3,000 bond on the charge of simple battery against a police officer. If he bonds out, he can only be released to any holds that he has.
Yes, ma'am. I'm sorry.
I mean, does that answer your question?
Yes, ma'am.
Would you still like to move forward with the plea, or would you like to plead not guilty and have a trial?
Just move forward.
Oh, all right. As I was saying, are you satisfied with your legal services?
Yes, ma'am.
Are you entering a plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty to these one count of criminal trespass and one count of theft by taking involving Georgia Tech property, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court with your lawyer. You will not be able to confront your accuser, challenge the evidence brought against you, present any defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up those rights?
Yes, ma'am.
How do you plead to one count of criminal trespass at Georgia Tech property from November 27, 2023?
Guilty.
How do you plead to one count of theft by taking from Georgia Tech property on January 11th, 2024?
Guilty.
For the criminal trespass, your sentence is 12 months to serve 44 days, credit for time served 2 days, to serve 4 days, credit for time served 2 days, with the remainder of the time to be served on probation. While you're on probation, you will report every month, and you are to stay away from all Georgia Tech property. For the theft by taking, it will be concurrent to the sentence I've just given, with the addition of undertaking an anti-theft class, which you must complete within 60 days of being released, and complete a 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. And you must begin that within 30 days of beginning probation, and you must complete at least 5 hours a month.
Yes, ma'am.
This probation will only begin after you have been released from all holds, including any other holds you may have in Mississippi or any other jurisdiction.
Yes, ma'am.
So in other words, the clock doesn't start until you're released from all your holds. As indicated, the only remaining open pending case in state court is 23 CR 007-691A, at which time you are accused of simple battery against a police officer, and you've got a $3,000 surety bond with no contact with Earl Hammonds. All right, once you make that bond, then that will be a release only to any other outstanding holds you may have, including Mississippi.
Yes, ma'am.
Thank you.
Next, we have Mr. Wright David. And that
Excuse me, I'm sorry, is there a Spanish interpreter for position number 1 and position number 17?
Do we have a Spanish interpreter on Zoom? No.
Judge, I did make a request for one yesterday and was told that my request was received.
I know, but until one appears, hopefully they will appear before the end of this calendar.
Judge, I'll check on it now.
Thank you.
Thank you.
Ms. Vigiletti, on Colby Walding, are we transferring that case, Ms. Falk, or am I going to reset that case pending a transfer?
Your Honor, if you could go ahead and reset it pending a transfer. As I stated, we had some additional information we needed to provide to the DA's office, which we provided yesterday, and I'm still waiting for a response.
All right, I'm going to reset it to March 19th, SAP calendar.
Thank you, Your Honor.
And I do beg your pardon. Medical, is that the case you need an interpreter?
yes.
All right. Ms. Vigiletti, who's the gentleman next to you?
Yes, Judge, this is Mr. David Wright.
David Wright is position 46.
Yes, 46 and I believe 47.
Yes. Mr. David Wright, your case number is 22 CR 662E, in which you were accused of driving under the influence of alcohol less safe and driving while license suspended and revoked from December 8th, 2020. You've got a bench warrant matter 24 FTA 227. You have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. And how are we proceeding, Ms. Vigiletti?
Yes, Judge, Mr. Wright would like to enter a not guilty plea today, and we would like to be heard on bond.
Okay. And are you filing a waiver of arraignment or or just waiving reading of the accusation?
I can file a waiver.
All right, so Mr. Wright, your attorney is going to file what we call a waiver of arraignment and enter a not guilty plea, and both your cases are going to be further notice for trial. With regards to position 45, right, looks like we had a failure to appear on September 2nd, 2022. And a bench warrant was issued. And Mr. Wright currently has a bond of $4,000. It's a surety bond for failure to appear in court to address the DUI case. He's also got a hold. And looks like it's in Douglas County. Ms. Washington, could you enlighten me on what that hold is for?
This is for Mr. Woodard, correct?
Mr. David Wright, position
David.
46.
Give me 1 second, Your Honor.
Oh, man.
Okay, I see a probation violation out of Douglas County, Douglasville. The warrant date is July 27th of 2023, and that's for a probation violation.
And do you know what the underlying offense is?
It says a reckless driving case.
Okay. All right. Yes, Ms. Vigiletti? You're on mute, please.
So regarding bond, Mr. Wright, so there is a dispute of fact in this case, so he would like to take it to trial, as is his right. He is being held at a $4,000 bond. Mr. Wright, I guess there are two primary reasons that I'm requesting bond today. First, Mr. Wright did know about the hold he has in Douglas County and would like to get it resolved as quickly as possible. I understand that that hold might not take very long to resolve. It is a driving offense that he should be able to resolve quickly, but he also would like to be released because he is in need of and actually was scheduled for a surgery at the end of the month last month. Mr. Wright, what started out as a tooth issue has become a very serious impacted tooth problem that is now impacting his vision. His vision is now blurry. He has daily headaches. He's unable to sleep. That surgery was scheduled through Grady, but because he was incarcerated, he was not able to make the surgery, and he would like to be released to be able to get his other criminal and also medical issues taken care of as soon as possible. I'll add, Mr. Wright has pretty significant community here in Atlanta. He does have a daughter who's 12 and a son who's 10 that he sees regularly. He lives with his father. He's been here since 2006. He originally came on a basketball scholarship, and you know, you can kind of see that he has sort of a string of charges all in this short period of time, but since then has really been trying to turn his life around, get these cases resolved. He has voluntarily started going to counseling at a clinic on Battle Creek Road in Riverdale. And so I do think he is very motivated to get these cases resolved and will appear for court when his case is scheduled for such.
All right, thank you. Ms. Falk, I did not ask for his GCIC. I'm afraid that was my oversight. Do you have it?
I do, Your Honor, and I will say that I am not being hyperbolic when I say that almost half of his history is failure to appear. So he has a failure to appear from this event, March 1st, 2024, a failure to appear February 20th of 2024 in DeKalb County. He has a failure to appear February 26th of 2023 in the Douglas County Sheriff's Office. He has a failure to appear from going back through his history, and this is beyond the actual charges he was also charged for and has pled to in the past. He has a failure to appear in, he had a probation violation in the Fayette County Sheriff's Office in 2014, a failure to appear in a probation violation in 2011 in Fayette County, probation violation in 2008 in, it just says Judicial Correction Services, Riverdale Police Department, a failure to appear in the Fayetteville Municipal Court in 2009, a failure to appear in, let's see, there was one more, let's see. A failure to appear in Riverdale in April of 2009, which he did eventually plead to that charge. In addition to that, Your Honor, he has a history that is littered with driving offenses as well. He has a driving while license suspended where he pled nolo in 2015, an arrest for driving while license suspended in Lamar County in March of 2017. That is not showing a resolution. March of 2017 in the Griffin Police Department, he pled guilty to a 2018 driving while license suspended. He had a 2019 hit and run, possession of a controlled substance, Schedule 1, driving while license suspended, willful obstruction. That is showing in Gwinnett County Superior Court. He pled to that in October of 2019 and received 3 years probation. He has a driving while license suspended in July of 2020 in Auburn Municipal Court. That was later null prost. Driving under the influence of alcohol and driving while license suspended in December of 2020 in Atlanta Municipal Court. That was bound over.
That's this case.
June, pardon?
That's this case, isn't it?
June of 2021, a Decatur Police Department DUI, that is not showing a disposition. July of 2021, a Douglas County Sheriff's Office driving while license suspended, that was null prost. A possession of methamphetamine, January of 2024 in Henry County, that is currently still open, and that is all. So, a lot of failure to appears, and we have yet another one here today. I do not feel that he is a good risk on bond. In fact, based on the Ayala factors, he's a terrible risk on bond for just failing to appear as many times as he's failed to appear. And for that reason, the state asked that the bond remain as set.
Ms. Micheletti, anything else to add?
No, Judge, I'll just reiterate. I spoke to Mr. Wright a couple of times, yesterday and also today, and I understand he has significant history, but I do just appreciate that he has taken it upon himself to enter counseling. He recently took a DUI risk reduction course of his own volition, he tells me, and my request today for a bond modification is based on this man's desire to make a change, and I do understand he has a significant history, but am requesting a signature bond or bond reduction based on the motivation to get this resolved and make a change.
On the DUI, driving under the influence of alcohol less safe, that's a $2,000 surety bond. On the driving while license suspended or revoked, that's going to be a $2,000 signature bond through pretrial services, level 2. He will report to pretrial twice a month. No driving at all. He is to be subject to random screens for illegal drugs and alcohol, so no consumption of illegal drugs and no alcohol, no possession of firearms.
Thank you, Judge.
If he fails to report to pretrial twice a month, if he fails a drug screen or an alcohol screen, his $2,000 signature bond will be revoked and we're back to square one, which is, providing that he makes the other bond. So this case is further notice for trial. Thank you.
Thank you.
We have ACDC. May we have another person up? Deputy Milton?
Yes, Your Honor. Can we go ahead and do the probation revocation one, Miss Position 5?
That's-
Floyd Jones?
Yeah. Ms. Jones, if you could please approach the monitor. Would you be able to unmute it?
Give me a second, Your Honor.
Yes, ma'am.
Okay, she got it.
Sorry, Miss Milton.
You said, which position is this, Officer Brooks?
What's the name of the probationer?
It's probation case 5 and 6. The last name is hyphenated, Floyd Jones.
I see. Okay, sorry about that. This is Miss Secretia Lynette Floyd Jones, case number 20, well. Case number 23 CR 1467D, in which Miss Jones, Floyd Jones, was convicted of one or more of the following offenses: driving under the influence of alcohol less safe, endangering a child by driving under the influence of alcohol, reckless driving, hit and run, and driving without a valid license. The alleged offense date was from November 7, 2020. Ms. Floyd Jones, you've got 2 probation violation matters, 24 PV 314 and 24 PV 316. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Officer Brooks, when was Ms. Floyd Jones convicted of this DUI matters?
April 24th of 2023.
And why is the state seeking a revocation, and what's the recommendation?
Thank you, Your Honor. She was sentenced to 12 months probation and to complete 240 hours of community service, to do a drug and alcohol evaluation within 30 days of release, to do monthly random drug screens, to complete a risk reduction program and a victim impact panel. There was a revocation hearing October the 13th in front of Judge Edline that the probationer did not show up for, and the judge reset it to October 24th. When we had the revocation hearing on October 24th, the probationer did not show up and the judge issued a warrant. The probationer last reported on September the 19th of 2023. She never completed any of her conditions except for one random drug screen that was performed here in the office, and she did fail that with a positive drug screen for THC. And that is why we are here, Your Honor.
What's the state's how many more days left on probation?
She has 81 days remaining on probation, and we are requesting to continue her on probation.
Alcohol, 240 hours of community service, which will not be done in 81 days. Alcohol and drug evaluation, risk reduction, and victim impact panel, and she failed a drug screen. Okay, Mr. McLean?
Your Honor, while not every single element can be done the next 80 days, if the court were to follow the recommendation of the probation department, that would be grand, because she can do as much as she can, everything but the 240.
Your Honor.
Yes.
I'm sorry, and I forgot to say that she has a court fine balance of $2,071, as well as a probation fee balance of $280, crime fund fee of $63, and a $25 drug screen balance. Thank you.
And she's not going anywhere. She's got a felony case. She hasn't made bond. She's got a $15,000 bond.
I've already been served.
It's a
I did that already.
Let me check.
Yes, ma'am.
This is 23 CP 215765. Ms. Strong, do you have that case?
What was the case number, Judge?
223 CP 215765.
Give me 1 second.
First appearance for 1 count of aggravated battery and 1 count of theft by taking from a January 25th, 2023 incident. First appearance was held on January 30th, 2023. Looks like she was incarcerated and then bond was set, bond was granted on May 1st, 2023 for $15,000, good bond. So you made bond.
Yes, ma'am.
But that is still an open, active felony case against you. That case is not closed.
I haven't been in trouble, Your Honor.
I'm telling you now.
Yes, ma'am.
This is an open, active felony case for aggravated assault on top of your DUI sentence that you've never complied with. You've never done any of the programs. You're $2,000 behind in fines. You've not paid your probation fees. You've not done your 240 hours community service. You've not done anything.
Your Honor, I have my mother on the other end. She's on the other end. She's willing to help me as far as staying stable. I was homeless. She's helping me to stay stable. I have support. My mother is on the other end, and I have guaranteed not to get in no trouble, Your Honor.
Please don't give me guarantees. I just
Yes,
need to see what's going on. All right, Mr. McLean, yes, that would be grand if I can continue on probation, but this doesn't paint a pretty picture. Is someone here for Miss Floyd Jones?
Her mother.
Yes, ma'am.
Who is that? I don't know who that is. I have
Jennifer
someone
Matthews.
All right, oh, Miss Matthews. All right, Miss Matthews, you need to start your video, please. I mean, it's a very pretty picture, but you need to be on video in order to.
Thank you, Your Honor.
There we go.
you.
Thank you. The host has, okay. Okay, I'm trying. 1 moment. Oh, jeez.
And Officer Brooks, tell me what's the outstanding fine right now? 2,000?
Let me go back to it, Your Honor.
What
Right
is-
now is $2,071 for the court fees and fines.
$71. Okay.
Wow. I'm trying. I apologize. I'm trying to.
Okay. Miss Grace, can you prompt the Zoom user to start video? Maybe that would help.
Yes, ma'am, I did already.
She's trying to find her apparently to start the video. There we
I
go.
just did it again, Judge.
Okay. Is it doing it?
No.
Okay.
All right, Miss Matthews. Your daughter
Yes.
is $2,000 behind in fines. She's not done anything for this DUI sentence. Why should I not just keep her in jail and finish out her sentence?
Well, ma'am, Your Honor, she has been working and staying out of trouble. I can honestly vouch for her on that. She works at Wendy's. She's taking care of her daughter. She has a place to live now. And I do believe that she's made a change in her life. I truly believe that. And I know her best, you know.
She's not reported to probation at all.
Yes, I have. I have.
Failed a drug screen.
Yes, ma'am.
I will.
While she's looking after a child, she fails a drug screen.
I go there every day to make sure everything is okay. That is in the past. Now she is doing excellent compared to how she was doing before. I can make sure that she can get to her. I will, if I can be, on the list of as far as when she has her probation, dates, I will be,
She needs
I
to
can
pay her
assist her.
fine of $2,000 within the next 30 days. Would you be able to help her?
I will be able to help her.
Okay, thank you. You may
Yes,
mute.
ma'am.
Mr. McLean and Ms. Floyd Jones, I'm going to continue you on probation for 81 days. You're going to report to probation every week, once a week, beginning with this Thursday, March 14th, before 3 p.m. If you
Yes,
fail
ma'am.
to report, you will be back in jail.
ma'am.
You
You will
are,
not fail.
please be quiet, Ms. Matthews.
Sorry.
You will report to probation, and like I said, once a week. You are to pay your outstanding fines and fees of $2,071 within 30 days. So by your fourth visit, which will be 1, 2, 3, by March 4th, by April 4th, April 4th, 2024, probation must confirm that they have received $2,071 to cure the amount of fees that you are owed. You will do the alcohol and drug evaluation and treatment within 30 days from today. By March 4th, you must go to Grady and complete your alcohol and drug evaluation and submit yourself to any treatment. Within 30 days, you must complete your risk reduction program and attend and complete the victim impact panel. The 240 hours of community service hours is converted to a $250 additional fine, since the likelihood of you paying that is going to be very small. Completing that community service is very small. So in addition to outstanding fines, you have an additional $250 fine, which you can pay off by the end of the remainder of the 81 days. If you fail to report, if you fail a drug screen, if you fail an alcohol screen, you will be back in jail to serve day for day. No 2-for-1 benefit. Thank you.
Your Honor,
Yes, Officer Brooks?
what was the deadline for the evaluation?
For the alcohol and drug evaluation, the risk reduction, and the victim impact panel is all 30 days. Would she be able to do the victim impact panel within 30 days?
Yes.
Okay.
Your Honor, I have an announcement. Position number 36, Mr. Townsend, he's in site observation.
All right. So we're going to reset him to March 19th. 36, you say? All right, thank you.
Excuse me, Judge.
Yeah.
I did get in touch with Miss Lucia. She said as soon as she can get off the highway, I sent her.
Your Honor.
Yeah.
I'm here. I'm available. I think because of my location, would it be okay if I stay off camera?
That's fine, as long as you're not driving.
I'm not driving. No, Your Honor, I'm not. And
Okay.
can you hear me okay?
Yes, loud and clear. Thank you so much, Miss Lucia.
Okay.
All right. With the jail facility, have the first, okay, as soon as the jail produces the defendants who need a Spanish interpreter, we'll call you, Miss Lucia. All right, please hold. Thank you.
Yes, Your Honor.
All right. ACDC, who do we have next?
And Your Honor, while they're bringing her.
Go ahead, Paul.
No, I apologize for interrupting ACDC. Who is the next defendant?
Next person is Gillette Pulliam. Position 28.
Appreciate it. Thank you. And what was your announcement, Mr. Paul?
Yes, Your Honor. The state's announcement is on position 17 and, excuse me, let me just make sure I'm back in the right place, 18 and 19, which is Floyd Irving. The state was able to complete their review of those cases, and it appears that the defendant had entered a plea on his case back in 2000, I want to say 16, but then somehow his name was inverted and he was the case was accused under 17 CR 00185337H. And he bench warranted on that case and was arrested, but the case had already been closed. And so the state went ahead and submitted null process on both 18 and 19.
All right. Ms. Vigilante, is that your client?
No, Judge, that is Mr. McLean's client.
All right, Mr. McLean, if you're ready to address Ms. Pulliam as well.
Ms. Pulliam is actually, should be represented by Ms. Maureen McLeod. That was the announcement I made earlier at 9 o'clock.
All right. It's already noon, my goodness. Miss Gillette Pulliam, your case number is 24 CR 1012E, in which you are accused of two counts of simple battery, 1 count of simple assault, and 1 count of criminal trespass. Your offense date is January 8th, 2024. Have you been in discussions with attorney Maureen McLeod?
Yes, ma'am. For one case, it seems that you guys have 2 of my cases combined together.
I only have the one. Oh, yes, there's another one here for 24
There is an add-on, Your Honor.
Yeah, that's another case, 23 CR 2681E. Miss McLeod is not present. I don't know where she is, and I don't know why she's not here. We started at 9 o'clock. She's not been here for over 3 hours. So I'm going to.
Do you want me to reach out to her, or you?
Yes, please. If she doesn't respond, then I'll have to reset the case to Thursday.
Okay.
Right. So
and
Ms.
this
Pulliam,
is position what now? I'm sorry, Judge.
28 Gillette Pulliam.
Thank you.
All right, Ms. Pulliam, please hold, and we'll wait to see if Ms. McLeod shows up before the end of the calendar.
Yes, ma'am.
Okay. Medical, who do we have?
Position number 18 and 19, Flora Irving.
All right. Mr. McLean, your client's case with Floyd Irving is dismissed, null prost, and if he has no other holds, he'll be released.
Very good. Thank you.
Thank you. The case is dismissed, sir. All right. Ms. Pulliam, you may have a seat at your chair. And the next young lady who has not been addressed, you may come forward. Deputy Milton, who would that be?
This is Ms. Stone.
Yes, Your Honor.
Who is this, please?
Ms. Stones, STONES.
Position 34.
This is not guilty. We're going to waive formal reading of the accusation and mention bond, Your Honor, bond request.
All right. This is case 20 CR 4971F. Curina Stones is accused of simple battery family violence from October 7th, 2020. Ms. Stones, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. As I've indicated, you are accused of a misdemeanor offense of simple battery. Upon your entry of a not guilty plea, the case will be further noticed for trial. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution does prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and is going to be further noticed for trial. With regards to this particular matter, 34.
Can we pause for just a moment? I need to see about some noise in the background here. It seems to have died down. Thank you.
All right. Ms. Stones had a bench warrant issued by Judge Richardson on June 1st, 2020. And I'm assuming that's the bond that's holding her in.
That's not the only thing holding her in, Your Honor.
Okay,
Your Honor,
Um,
she's being held in with a $10,000 bond on one count of theft by deception. And
okay, here it is.
she has a couple of holds.
She has 2 foreign holds, one from DeKalb and one from Fayette.
All right, the bench warrants for 1,500.
I think it's 1,000, but that's what I was told by the record room.
Oh, it's 1,000, excuse me. Has she? All right, no, she had a prior bond for 1,500, which she paid. And when she didn't show up to court, Judge Richardson issued a $1,000 additional bond for the bench warrant. And then, yes, she does have a $10,000 surety bond on the felony charge and 2 holds. All right, and Mr. McLean, the reason for the bond request?
Your Honor, the court might want to consider a signature bond, reinstating it as a signature bond so that it would cause the other cases to move forward. However, that's not an Ayala factor. That's not what we're saying. It's just that it's a 2020 case and it's her putative daughter-in-law. And just looking at the nature of the case, that's the request.
All right, I'm not sure I understood that, but I will, Ms. Folk, anything else to add?
Yes, Your Honor. The defendant failed to appear in 2021. This is actually the second failure to appear. In June 7th of 2021, there was a failure to appear to plea an arraignment before Judge Richardson. Judge Richardson reset this further notice. Then May 31st of 2022, there was another arraignment calendar where the result was a failure to appear, at which point a bench warrant was issued. The only reason this case is 4 years old and still sitting around is because the defendant fails to appear on her court dates. And so for that reason, the state would ask, based on the Ayala factor of failure to appear and the fact she is a flight risk, clearly she is, she hasn't appeared twice on the same case. We are asking that the bond remain as set at $1,000.
Mr. McLean, anything else to add?
Nothing further, Your Honor.
Okay, bond request denied. Thank you. Deputy Milton, do we have any other matters?
Your Honor, Quinetta Jones, position 22, I have to go and get her.
Okay.
I have to take the ladies with me and I'll be right back.
Okay, do you have any cases that require a Spanish interpreter?
No, Your Honor, not,
Okay.
I believe that was in medical with Officer Blunt.
Okay,
Sometimes-
appreciate it. We'll hold for you. Thank you.
Let's go, we'll be right back.
All right,
You finish.
and we can mute ACDC. Mr.
Excuse me, Your Honor. Are you finished with Miss Stones?
Yes, her bond modifications denied. She's got a $1,000 surety bond on her bench warrant and her felony matter.
I do have a surety bond. I just wanted to clarify.
You have a $1,000 surety bond on the bench warrant.
Okay.
And you have a bond in your felony case.
Right.
Deputy Milton, will you explain that I will come to the ACDC and explain further?
Yes, sir.
Thank you.
Okay, thank you.
Does the jail facility have any
Yeah,
individuals
if we
who,
bring this whole point, PD Abden is here to address the add-on position 1. Zachary Alexis, I believe is his name. Yeah.
there is an add-on, yes. Is Ms. Abden, is this a matter that requires a breakout or are we okay in open court?
Judge, I would request a breakout room due to MA.
All right, Ms. Strong, if you could place me, Ms. Falk, and courtroom 2 in a breakout session, please.
Okay, Judge.
I know, I've seen this stuff.
There you go.
I was like getting ready to get out.
Go.
All right, with regards to the add-on case, that matter is gonna be reset to this Thursday at 9 a.m. All right, moving on, Ms. McLeod, yes, hello, Ms. McLeod.
Good afternoon, Your Honor.
We have your
Ms.
client,
William.
William. She's still at ACDC. I think Deputy Milton's gonna be, can you stay with us for a while?
Yes, Your Honor, I can stay with you. I also looked at the calendar and see that I have another client. Well, someone I am representing on some other cases who apparently was recently arrested. I was unaware of that. It's O'Garis McGee, I believe his name is.
Yes, position 27.
Yes, Your Honor.
He's got yeah, this was a global recommendation. So O'Garius McGee has not appeared yet.
It's a reset for 2 days so that the state can make a global.
Oh, I see. Okay. Ms. McLeod, would you be available this Thursday?
Yes, Your Honor, I believe so. I can check my calendar.
Okay.
I may have something at the courthouse, but Mr. McGee is kind of a special case.
Okay.
So I would love to speak to Ms. Falk about him.
Okay, so please understand that he's got this current case, 24 CR 001-008A, simple battery family violence. He's got second case, 23 CR 004-765B and 23 CR 004-766B.
I'm representing him on those two other cases, Your Honor, but I was unaware that he had this new charge.
Okay, so those are, and then Miss Pulliam is at ACDC.
Yes.
Right, position 28, Miss Pulliam, your attorney is online. And Miss Pulliam, how would you like to move forward with Gillette Pulliam?
Well, I need to speak with her, Your Honor, because we were actually in physical court on the jail calendar most recently, and that was reset for a jury trial. So I need to speak with her about the state's new global resolution, which I see, and see how she feels about it.
And Deputy Milton, do you have another case behind you?
I've got Miss Quinetta Jones.
All right, let me address Miss Jones, and then we're gonna put ACDC in a breakout with Miss McLeod.
We can use, can you call us, Miss McLeod?
I can.
404-865-8112.
Did you say 865?
865-8122.
Okay, I'll call.
All right. This case is Quinetta Jones, 24 CR 887F. Ms. Jones is accused of simple battery at a public transit vehicle or station and criminal trespass from February 24th, 2024. Ms. Jones, you have been advised of your right to remain silent, and your attorney is Mr. Michael McLean. Mr. McLean, how are we proceeding with your client's case?
This is a non-negotiated plea, Your Honor.
Okay. Ms. Jones, may I place you under oath for purposes of the plea if it moves forward? You have a right, do you swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay. The prosecutor, Ms. Falk, is first going to give her recommendation. You can put your hand down. And then your attorney will give me a recommendation. I will let you know which recommendation I'm going to accept before we move forward with the plea. Ms. Falk?
Yes, Your Honor. This is a simple battery in a public transit vehicle and a criminal trespass. The incident happened back on, let's see, February 23rd of 2024 at approximately 6:56 a.m., station maintenance worker Patricia Lane Parker reported an assault at the Arts MARTA train station. She was performing duties related to her station maintenance when she observed the defendant approach her in an aggressive manner, questioning if Miss Lane Parker knew her. She then threatened to kill Miss Lane Parker and pushed her with both her hands and her body. In the course of the altercation, the defendant picked up a box and threw it. Miss Lane Parker attempted to retrieve the box and then reported that the defendant physically assaulted her by swinging at her. The defendant then went inside the train where Miss Lane Parker was able to capture a photograph of her at the train door. Miss Lane Parker did not sustain any injuries. However, the state's recommendation was 12 months probation, served 90 days, credit for time served 18 days, balance probated, 12 weeks anger management, stay away from all MARTA stations, no further contact with Patricia Lane Parker, and count 2 was 12 months probation to run concurrent with count 1. That is due to the history of this defendant. This defendant has, at this point, 19 cycles, most of them involving some form of violence. So starting kind of with the most recent, she had an aggravated assault arrest that was dismissed. That came out of, let me just double check something for a second. That was on September 7th of 2022 that involved MARTA Police Department as well. She had a simple battery, willful obstruction of a law enforcement officer, possession and use of drug-related objects. That was March of 2022, an arrest by MARTA police. She ended up pleading guilty to possession and use of drug-related objects and received 12 months with 32 days to serve. She had a criminal trespass in 2022 in DeKalb County State Court. She was convicted July of 2023 and given 10 days confinement. She also had a simple battery in Clayton County State Court, disorderly conduct, and another simple battery. She was given 12 months suspended, 60 days to serve. She also had just a moment, let's see, criminal trespass out of Clayton in 2019, where she was given 12 months with 14 days to serve. Showing a battery, family violence, a battery and disorderly conduct. That's out of DeKalb County Superior Court. In 2018, she received a total of 36 months to run on probation on that case. And that was pled down from, it looks like, a aggravated assault, family violence. She also has looks like another simple assault in our court. And let me just go back to my notes on this. It looks like she also had a previous case in 2015 of simple battery and criminal trespass. That case was closed. She was found guilty of simple battery and criminal trespass. That was in 2015. And then another simple assault, criminal trespass in 2016. That case was closed and she was found guilty of that as well. So as I said, her history is pretty littered. Her most recent conviction, she received 60 days to serve, and the state would not depart downward from that amount of time she has served previously. The state would sound for Miss
Patricia
Lane Parker, and the state has nothing further to present.
Miss Patricia Lane Parker. All right. Mr. McLean, anything else to add?
She has a disability check, Your Honor, that evinces that she does have a legitimate mental health diagnosis. She is now on her meds. As long as she stays on her meds, there shouldn't be any problem. She has already been in for the 18 days, which would be the equivalent under a 2-for-1 rule for 36. If Your Honor could make the 12, 90, 18 instead something less than that, such as if it were 12, 36, 18, that would be time served on the jail portion. The 12 anger management classes will be performed. She could do additional community service. The court could add a requirement. There's no point doing an MHE because that's already established. Court could add an order that she stay on the meds, something like that. There are other special conditions that could be added, but she would like to go home as soon as possible.
Understood. I'm accepting the state's recommendation to serve 90 days, credit for time served 18 days. The remainder of time she'll be on probation to report every month with compliance with medication and the anger management classes, as well as to stay away from all model property for the 1 year. Ms. Jones and Mr. McLean, would you like to move forward with the plea or would you like the case arraigned?
I think we are moving forward with the plea, Your Honor, based on my discussions last night. I don't think we need a breakout for that. We discussed several possibilities. Am I correct, Ms. Jones?
Yeah, I just want to ask, so would that still mean that I got
27 extra, it'll mean 27 extra days at this point.
Is how many?
27. You'll be out basically 3 days shy of a month from today. You'll be
I still get out April the 8th?
Approximately April the 8th. Yes, we did calculate that.
Okay.
Okay.
Then after that, you'll have to be on probation to do the anger management classes and stay away from all model property for 1 year.
For 1 year?
For, well, 1 year less 3 months, so for 9 months.
Okay, okay. That's what I'll do.
Okay. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea, yes.
Ms. Jones, have you consumed any medication or alcohol recently?
No.
Have you understood the proceedings so far?
Yes.
Have you understood your attorney?
Yes.
And are you satisfied with the legal services you received?
Yes.
If you decide to plead guilty to simple battery at a public transit vehicle or station and criminal trespass, you would have to give up your constitutional rights to a trial before a judge or a jury. You will not be able to go back to court with a lawyer. You will not be able to confront your accuser, challenge the evidence brought before you, present your defenses and arguments, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering a guilty plea freely, willingly, and knowingly?
Yes, ma'am.
How do you plead to simple battery against Patricia Lane Parker at a public transit vehicle or station?
Guilty.
How do you plead to criminal trespass?
Guilty.
Your sentence is going to be 12 months to serve 90 days, credit for time served 18 days. You have an additional 27 days to serve at the Fulton County Jail. Once you are done with this additional time, you will be released, after which you would immediately have to report to probation at the first business day on Monday, Tuesday, or Thursday. The location is 132 Mitchell Street in downtown Atlanta. You will report every month. While you're on probation, you will complete 12 anger management classes, which you must begin within 60 days of being released. At all times while on probation, you are to have no contact with Patricia Lane Parker. You have to stay 200 yards away from her and not communicate with her in any way, form, or manner. You're also to stay away from all model property, including the railway, the buses, and their stations. And this will be while you're on active probation. Thank you.
I'm done.
You're done.
Thank you.
Ms. McLeod, how would you like to proceed with Ms. Pulliam?
Your Honor, my client will not be accepting the state's offer on any of her cases. She wants to have a trial.
Okay, and will you be filing a waiver of arraignment or would you like me to arraign the cases?
I'll file a waiver of arraignment.
Okay. Ms. Gillette Pulliam, your lawyer will be filing a waiver of arraignment in all the 3 outstanding cases before you. You are essentially entering a not guilty plea, and the case will be further noticed for trial. Anything else, Mr. McLeod?
No, Your Honor. I do want to speak with the state about my other case on Mr. McGee's.
Understood. Thank you. Mr. McGee has not appeared, so this is something you probably have to do either through chat or let me
Yeah.
find out from courtroom 2. What's the status of the remaining inmates?
Your Honor, just to remind the court, Mr. McGee's case is the one with the several add-ons that the state asked to reset because there were 2 additional cases and we need to address
You're
them.
right. Yeah, sorry about that. I'm trying to keep track with everything that's going on. All right, so that
apologize.
case has been reset.
What
Yeah.
day are we reset? You said.
This
you said
Thursday.
Thursday. Okay, thank you.
Subject to Miss McLeod being available. I think she's going
I have to check my calendar now on Thursday.
I
Just
thought
a minute.
initially we had said Tuesday, so were we going for Tuesday or were we going for Thursday?
I thought it was Thursday, but if Tuesday is better for you, Miss McLeod?
I'm gonna take a look and see.
Okay, thank you. Deputy in courtroom 2, any progress with our Spanish-speaking defendants?
But did you ever get the Spanish interpreter for the ground? I had him while I was in the, I thought they said that he was gonna be used to, so I took him back. I think the Spanish interpreter on there now.
The Spanish interpreter is available. I was just wondering, Mr. McLean and Miss Vigilante, which cases were the ones requiring a Spanish interpreter?
Miss Vigilante had one. I don't have any.
Which case was that, Miss Vigilante?
Position 1 and position number 6. I thought
Oh, Nestor Alberto. Okay.
I thought someone said that they was resetting his case, so I took him back to housing.
Miss Vigilante? Would you be able to address that on Thursday? Uh-oh.
I'm sorry, Your Honor, did you call out for me?
No, I was trying to find out where the defendant was for the
Oh, okay.
Spanish-speaking case.
All right.
Miss Vigilante? I think your audio is off. Okay, I'll wait for that. Miss McLeod, any update on your availability?
Yes, Your Honor. I see that I have Judge Taylor at 9:30 on that morning and a
Okay.
Superior Court matter at 11 o'clock.
Right, do you think you'll be available after 11 then?
Yes, Your Honor. No, the
other
matter
one's at 11.
probably
Okay.
a bit, maybe 11:45.
Okay, then in that case, would Tuesday be better?
Let me see, Tuesday. What date is Tuesday now? The 9th?
It's the 19th.
Let me see. Your Honor, that is also full, but I have Mr. McGee down on that day before Judge Porter. Actually, we were supposed to have motions in his case before Judge Porter at 9:30 on Wednesday, actually.
All right. Well, on motions. Okay, let's shoot for next week then, and then
Yes, Your
hopefully
Honor.
Judge Taylor will give you a few moments to step outside and do this.
I think that is possible, Your Honor.
Okay. Ms. Strong, on Ms. Pulliam's case, we're going to reset it to March 19th at 9 a.m.
I thought we were talking about McGee.
Oh,
No, McGee.
McGee is going to be with Judge Taylor.
No,
No, Your Honor. Judge Taylor is a separate case. I was just saying, Judge Taylor, I had another client before him on Thursday morning.
Okay.
But Mr. McGee, his cases that I was handling before are before Judge Porter.
I
And
see.
I see where I have next week, Wednesday, a motions hearing in his case.
So do you want him on SAP or do you just want to take that up with Judge Porter?
Well, he's in jail and I'm not sure whether he has a bond or not. So,
And I apologize. This particular case, it doesn't have the current case is a Roth case, not Porter. I know they look like they just assigned it, but this is assigned to Porter, not it's assigned to Judge Roth, not Judge Porter.
Okay, let's get back to Miss Pulliam. Miss Pulliam, we're going to reset that to March 9th at 9 a.m. March 19th at 9 a.m.
March 19th, okay.
Okay, so Ms. Pulliam is March 19th at 9 a.m. And hopefully you'll get a moment out to address that at SAP.
Well, my client, I was with Miss Pulliam, I was going to file her waivers of arraignment, and she definitely has told me that she wants a jury trial.
You're right. I'm
actually
getting my
was
notes all
physically-
wrong with this. Okay, waiver of arraignment and further notice for trial.
Right, she was actually physically at the courthouse, I think 2 weeks ago.
Okay, and
For
that's
an
why I'm getting
jury
confused.
jail
McGee,
jury
yeah,
calendar.
McGee is right next to Pulliam on my calendar. All right, and so with McGee, your case is being reset to address the global offer. But right now, you have a case involving McGee before Judge Porter.
That is correct, Your Honor, and we'd worked out something with the prosecutor. I just want to let the court know, Mr. McGee has some MH issues.
Okay, so this is what I'm gonna do. Ogarius McGee, I'm gonna reset him to March 21st, which is next Thursday
Yes, Your Honor.
at 9 a.m. The reason being, if you resolve it on Wednesday, then that takes care of the matter on Thursday.
Yes, Your Honor.
Okay. All right. Thank you, Ms. McLeod. Sorry about all that confusion. All right.
No problem, Your Honor.
All right. I think that was the only cases, right?
To my knowledge, yes, Your
All
Honor.
right. Thank you so much. All right.
You want 7 and 8 on the probation revocation calendar is a behavioral reset.
7 and 8. Who represents Montavious Hawkins?
I do, Judge, and I was told by the jail staff that he couldn't be brought today.
Okay. We're gonna reset this to March 19th probation revocation calendar.
Okay, thank you.
So this is a reset behavior. Okay. Position 7 and 8 on the probation revocation calendar. Medical, who do we have there?
This is position 36, Anthony
Anthony
Townsend.
Townsend, okay. While we are also at medical, any luck with Mr. Nestor, position 1? Deputy?
I knew that originally. I don't know.
He was there originally, but unfortunately, our Spanish interpreter wasn't. Now our Spanish interpreter is present, but Mr. Nestor isn't. What would you like to do, Ms. Vigiletti?
Judge, I really, it's a very minor charge. He would be getting out today if we can find him, but he is on the floor above us. There's 2 medical floors. We're on a different floor than he's on. I know we're running late. Both of these gentlemen are time served. Officer Norris just said he's gonna get him and bring him here.
All right. I think he heard you loud and clear. That's why.
Yeah, I'm guilt tripping Officer Norris and he's gone above and beyond today.
You are such a baby bear, Officer Norris. Okay.
I know.
Okay. Anthony Townsend is case 24 CR 737Y. Mr. Townsend's accused of simple battery. Mr. Townsend, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. All right, Ms. Vigiletti, we had originally reset this to next Tuesday. Are we addressing this case today?
Yes, please, Judge.
All right, and how are we proceeding with it?
Mr. Townsend would like to enter the plea as negotiated today.
All right.
The only thing that I'll ask, Judge, Mr. Townsend has been chronically homeless, and one of the things that he and I have been doing together is working on finding him a good, stable place to live, which I think we have a good facility in mind for him, and he'll be able to actually just walk in once he's released. And I did just want to ask if you would consider waiving some probation fees, given his ongoing financial and housing situation.
I'll do that as long as he reports to probation. If he misses probation, all bets are off.
Okay, thank you, Judge.
All right, Mr. Townsend, please raise your right hand for purposes of the plea. Other right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's your recommendation for Mr. Anthony Townsend, position 36?
Yes, Your Honor. The state's recommendation is 12 months served 62 days, credit for time served 31 days. That is from February 11th to March 12th of 2024. No further contact with Albert Javier Outbridge. Stay away from Citgo located at 655 Cleveland Avenue in Atlanta, and 8 weeks of anger management. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea, and would like to sound for Mr. Albert Javier Outbridge at this time. Nothing further from the state.
Javier Outbridge? Okay. Officer Brooks, are we done with all the revocation cases? I think
Yes, Your Honor.
All right, thank you so much. You have a good day.
You too. Bye-bye.
Bye-bye. All right, Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right, thank you. Mr. Townsend, have you consumed any medication or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Do you understand that you have to stay away from the Citgo gas station?
Yes, ma'am.
And you need to report to probation every month?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And has it been explained to you that if you plead guilty, you would have to give up your right to go back to court and have a trial? You won't be able to confront your accuser, confront witnesses, challenge the evidence, and have your attorney help you to present arguments and defenses. You would also have to give up your right to have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery?
Guilty.
Your sentence is 12 months to serve 62 days, credit for time served 31 days. Balance probated. You will report to probation next Tuesday. Today is Tuesday. You will report next week on Tuesday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. I will waive your probation fees for March, April, and May. You will start paying probation fees on June 1st. Understood?
Yes, ma'am.
Within 30 days of being released, you must tell us a good mailing address for you. So you need to come back to court and give us your mailing address in writing.
Yes, ma'am.
While you're on probation, you will complete 8 weeks of anger management, and you must begin those classes within 90 days of being released. So I'm giving you 90 days to get a job, get money, and start those classes.
Yes, ma'am.
Also, do not return to the Citgo gas station at 655 Cleveland Avenue, otherwise you'll be arrested again.
Yes, ma'am.
Thank you.
Thank you, Judge.
All right, we'll be on hold. Medical, if you could mute your screen, please. Thank you. All right, this young lady on iPhone, what's your name, please? The lady in a white t-shirt on iPhone. I don't know what's your name. You need to unmute and identify yourself. What's your name, please? Courtroom 2, please mute.
So I don't have, I don't have a full calendar. I've just got the same.
Peggy Brown.
Oh, this is Miss Peggy Brown. She's on our bench warrant calendar. Let's go ahead and change her name from iPhone. Miss Brown, if you look at the Zoom, is this your phone?
Yes, ma'am.
Okay, you see on his phone, it says iPhone, so I had no idea who you were. Okay, Peggy Brown. Miss Brown, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney. And Mr. McLean, who's your attorney, Miss Brown?
I don't have one. I emailed.
You have a right to an attorney if you cannot afford one. One could be appointed to represent you. Would you like an opportunity to speak to a public defender?
Yes, ma'am.
All right, you understand that you've got a bench warrant issued against you for failure to appear in court.
Yes, ma'am.
Okay. Mr. McLean, would you like an opportunity to speak to Ms. Brown? You're on mute, sir. Mr. Michael McLean? We can't hear you.
Was pushing that space bar, which is supposed to unmute. Gosh.
No, I think if you push the space bar, it never works for me, but yes, sir.
Right.
Miss Peggy Brown is charged with a bench warrant, and she's filing a motion to set aside. Would you like an opportunity to speak with her?
Yes, before I do that, could I have Ms. Falk call me at 770-842-5471? And I think y'all probably, then I can talk to Ms. Brown. I saw in the chat what the offer was.
All right. First of all, Miss Brown, write down this number.
I'm ready.
770
Uh-huh.
842
Uh-huh.
5471.
5471.
5471.
Okay.
Give
That
me
is, yeah.
give me about 3 or 4 minutes, maybe 3 or 4 minutes, and then call me, Ms. Brown.
Okay, then I will do it.
Okay.
All right,
You can
I'll
either
call.
stay on the Zoom or you can call Mr. McLean, leave the Zoom, then come back in.
Okay.
All right.
In the meantime, it makes sense for me simply to call Ms. Falk.
Okay.
I'm about to call you now, Mr. McLean.
Mr.
Okay.
McLean, do you represent Mr. Nestor, position 1?
No, Your Honor.
Okay, Miss Vigiletti? All right, she's there. Excellent. Miss Lucia, are you available? Miss Lucia?
Yes, Your Honor. I'm sorry. I'm here.
No problem. Miss Lucia, do you solemnly swear and affirm the translation you provide will be true and accurate without any changes or embellishments?
I do, Your Honor.
Thank you. This is State versus Nestor Alberto.
Esta es la fiscalía en contra de Néstor Alberto.
Mr. Alberto has a bench warrant, case number 24221.
El señor Alberto tiene un caso de un juicio en frente del juez, el caso número 24221.
The bench warrant was issued because he failed to appear in court.
La razón por que la orden judicial de que aparezca en frente del juez fue hecha es porque no apareció en la corte previamente.
Mr. Nestor Alberto Nestor has an open case under case number 23 CR 4796A.
Tiene también el señor Néstor Alberto un caso abierto que es el 23 CR 4796A.
That case is for criminal trespass from August 3rd, 2023.
Ese caso es por traspaso criminal que sucedió el 3 de agosto del 2023.
In that case, his name is listed as Nestor Alberto Hernandez Dominguez.
En ese caso, el nombre que está puesto es el señor Néstor Alberto Fernández Domínguez.
Position number 17 on our calendar.
Que es la posición número 17 en el calendario actual.
You have a right to remain silent about the facts of the case. Anything you say can and will be used against you.
Usted tiene el derecho de permanecer en silencio sobre los hechos del caso. Cualquier cosa que usted diga puede y será utilizada en contra suya.
You have a right to an attorney. Representing you is Miss Vigiletti standing next to you.
Usted tiene el derecho a un abogado y la señora Vigiletti está parada al lado suyo y ella le está representando a usted.
Miss Vigiletti, how are we proceeding in his case?
Yes, Judge, I spoke with Mr. Hernandez Dominguez through his cellmate yesterday, and I believe he'd like to enter a plea, but out of an abundance of caution, I do think that perhaps through the certified translator, I should just very quickly make sure he understands the terms.
Okay.
We could also, I mean, potentially, this is a very simple case. We could also potentially just discuss it here and give him the opportunity to withdraw if.
You may proceed whichever way you like. I'll need Miss Lucia to go into a breakout with medical if you want to do it separately. Miss Lucia, are you able to go? Well, let me ask a different way. Miss Strong, are you able to put Miss Lucia into a breakout even though she doesn't have her video on?
Yes, ma'am.
All right. Miss Lucia, you're going to go into a breakout room. Medical, you're going to see a message on the screen to join a breakout room.
Thank you, Judge.
Thank you, Your Honor.
Don't forget to come back, Miss Lucia.
I won't. I'll
Okay.
be back, Your Honor.
All right, folks, we'll be in a brief recess while Miss Falk also. Miss Vigiletti, you should see a message on the screen to join a breakout.
I don't
Oh, Miss Grace, could you bring courtroom 2 out of the breakout room 2, please?
Bring courtroom 2 out. Okay, Judge.
Yeah, it was only Miss Vigiletti, medical and the interpreter. I think Miss Strong is taking care of that. All right, we'll be in a brief recess until somebody. All right, Ms. Nestor, are we ready? I mean, Ms. Vigilante, are we ready to proceed?
Yes, Mr. Hernandez Dominguez would like to proceed with the plea as negotiated.
All right, let's just wait for Miss Lucia is out too. All right, Miss Lucia, if you could unmute, please.
Yes, Your Honor, I'm here.
All right, I'm just waiting on Miss Falk.
I'm here, Your Honor.
Thank you. All right, Mr. Nestor, also known as Hernandez Dominguez, is going to move forward with a plea hearing. Miss Lucia?
El señor Néstor Hernández, vamos ahorita a tomarle el acuerdo, vamos a hablar del acuerdo.
Ms. Falk, what is the recommendation?
Your Honor, the state's recommendation is 12 months probation, serve 36 days.
Y la recomendación de la fiscalía es 12 meses de probatoria, haber estado en la cárcel 36 días.
The
Go
defendant, oh, pardon. The defendant will receive credit for time served 18 days. That will be from August 3rd to August 5th, 2023, and February 27th, 2024 until today.
Y el acusado va a recibir 18 días de crédito por su estadía penitenciaria en agosto del 2023, entre agosto 3 y agosto 5 del 2023, y entre febrero 27 del 2024 y el día de hoy.
The balance will be suspended, and we are asking for a stay away from the Economy Hotel at 9995 Old Dogwood Road in Roswell.
Y el resto de días, entre los 18 y 36, va a ser suspendido. También estamos pidiendo que se mantenga lejos del Hotel Economy Hotel, que está ubicado en el 995 de Old Dogwood Road en Roswell.
The state asked the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Y la fiscalía está de acuerdo en dónde está siendo ubicado este caso y necesita una identificación de usted para identificarlo y para poder llegar a este acuerdo.
We do stipulate, and I'll also just clarify with my client, because I didn't explain before that 36 days, credit for time served, 18 days is a time served offer.
Y su abogada dice que sí estamos de acuerdo con eso y nada más quiere aclarar con usted que la sentencia es 36 días, los 18 días servidos y la diferencia es suspendida, o sea, no la tiene que servir en este momento.
Mr. Nestor, could you please raise your right hand?
Señor Néstor, levante su mano derecha, por favor.
Do you solemnly swear the testimony you provide will be the truth to the best of your knowledge?
¿Jura usted que el testimonio del día de hoy será la verdad y solo la verdad bajo palabra de Dios?
You need to say yes or no.
Necesita decir sí o no. Yes.
You may put your hand up.
Puede bajar su mano.
Mr. Nestor, have you consumed any medicine or alcohol recently?
Señor Néstor, ¿ha consumido usted algún medicamento o alguna bebida alcohólica recientemente?
No.
No.
Are you satisfied with your legal services?
¿Está satisfecho usted con el servicio legal? ¿Perdón?
Sí.
Yes.
You need to speak loudly and clearly so you can be heard.
Necesita, por favor, hablar en voz alta y claramente.
Have you understood what's going on in your case so far?
¿Ha comprendido usted, comprende usted todo lo que está sucediendo hasta este momento en su caso?
Sí.
Yes.
If you decide to plead guilty to criminal trespass, you would have to give up your right to have a trial in front of a judge or a jury.
Si usted decide declararse culpable a la acusación de traspaso criminal, usted está renunciando al derecho de tener un juicio en frente de un juez y un jurado.
You will not be able to confront your accuser.
No va a poder confrontar a quien le está acusando.
You will not be able to challenge the evidence brought before you.
No va a poder revisar ni estar en contra de la evidencia que actualmente se tiene en contra de usted.
And the prosecutor will not have to prove the charge against you beyond a reasonable doubt.
Y la fiscalía no va a tener que comprobar la acusación en contra suya más allá de cualquier duda.
Are you prepared to give up these rights?
¿Está preparado usted para renunciar a estos derechos? ¿Perdón? Yes.
How do you plead to one count of criminal trespass?
¿Cómo se declara usted en la acusación por el cargo de traspaso criminal? Guilty.
Your sentence is 12 months to serve 36 days, credit for time served 18 days.
Su sentencia es 12 meses con el servicio de 36 días con crédito por los 18 días ya servidos.
The balance is suspended, which means you don't have any more jail time.
El balance es suspendido, lo cual quiere decir que usted no tiene más tiempo de cárcel en este caso.
If you have no other cases holding you at the jail, you should be released within 24 hours.
Si usted no tiene ningún otro caso por el cual debe ser mantenido en la cárcel, lo pueden dejar libre en las próximas 24 horas.
But you must stay away from the Economy Hotel at 9995 Old Dogwood Road in Roswell, Georgia.
Pero debe mantenerse lejos del Economy Hotel en el 9995 Old Dogwood Road en Roswell.
If you return to that location, you will be arrested again.
Si usted regresa a ese lugar, va a ser arrestado nuevamente.
Do you understand your sentence?
¿Comprende usted su sentencia?
Sure.
Yes.
That concludes the case.
Eso termina su caso.
All right. Thank you, Ms. Vigiletti.
Thank you, Judge.
Your Honor, may I, if that is all my business with the court, may I be excused?
Yes, Ms. Lucia. Thank you very much. Be safe.
Thank you, Your Honor. Have a good afternoon.
You too. Moving back to our bench warrant calendar with Miss Peggy Brown. Officer Norris, did you have anyone else at medical? No? Okay. Ms. Brown, you have conferred with Attorney Michael McLean. Mr. McLean, are we proceeding with your representation? Please unmute.
There we go. Yes, Your Honor, thank you. That's going to be a plea today.
A plea?
Yes.
All right. Ms. Falk, is that your understanding?
Yes, Your Honor, that's correct. I would also like to let Mr. PD McLean know that I put in the name of Robert McCoy and the date of birth of 4/2/71, which was in the police report. And I am not coming up with any arrests here in Fulton County. I'm just checking the jail record to be sure. And to 1971. And I'm getting no match found.
Very good. That works for me. We were just checking for conflicts, Your Honor, just to make sure. His name, the name was familiar, seemed familiar to me.
Okay. Miss Peggy Brown, please unmute your screen. This is 21 CR 006053J, in which Miss Brown is accused of 1 count of battery, family violence, 1 count of battery, and 1 count of simple battery, family violence, stemming from a January 4th, 2021 incident. This case was originally scheduled to address an outstanding bench warrant against Ms. Peggy Brown. Upon conferring with counsel, the Public Defense Office will be appointed to represent her. So Ms. Brown, your counsel is going to be Mr. Michael McLean. I guess the state and defense have conferred and you have decided to consider a plea recommendation. Please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Ms. Falk, what is the plea recommendation?
Your Honor, the state's recommendation on count 1 is 12 months probation, serve 4 days, credit for time served 2 days. That is from January 5th, 2021 to January 6th, 2021. Balance probated, family violence intervention program, no further contact with Robert McCoy, stay away from 189 Mill Street Northwest, apartment 102 in Atlanta, and no firearms. Count 2 and count 3 based on this, because they are based on the same fact pattern, will merge with count 1. I will just state for the record that Ms. Peggy Brown does not have any convictions on her history. Her last arrest was in 2004. We are also wanted to put on the record that Ms. Brown took the unusual step of coming into our office to try to resolve her case. I believe it was last week. And then had also gone to the clerk's office to try to resolve this case. It was then put on this calendar. She is suffering from health issues, which is in addition to her lack of any prior convictions, why the state made this recommendation.
Stay away from 189 Mill Street, Unit 102. That's her current mailing that's her current address. That's where she lives.
Let me just double check and see if she's still if the victim, Mr. McCoy, is still living at that address. Let me see what I can find.
She was originally living at Conley Road, and when she came to apply for the motion to set aside, she amended it to the Mill Street, so.
Mr. McLean, if you could assist with this, is the and let me try to check our victim advocate notes as well.
Because if I grant this plea, she'll have to move out of that house.
Right, and I'm not sure if those two are still living together at this time. And so that question is directed to PD McLean.
Okay, I can get back in a minute if we pause. I'll put us on mute and I can report back in about 2 minutes with the answer on that.
Thank you.
All right, Ms. Vigiletti, Mr. McLean, why don't you use the phone, and Ms. Vigiletti, if you could unmute, I'm just going to go over the calendar with you and Ms. Falk while we're waiting. Ms. Brown,
Yes.
your attorney is going to call you in a moment.
Okay.
Please mute your screen. Ms. Vigiletti?
Yes, Judge.
On the DV bench warrant calendar, we are addressing a plea for Peggy Brown. Position 2, James Williams did not appear, so that bench warrant will execute. That bench
Your
warrant.
Honor.
Yeah.
Your Honor, this is Tyson Bray from the Public Defender's Office. Mr. Williams is on the line.
All right. Where is he?
Yeah. He's right there, Your Honor.
All right. This is State versus James Williams, case number 23 CR 005143E. Mr. Williams was accused of battery, family violence, and 2 counts of cruelty in the 3rd degree on August 20th, 2023. Mr. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and I gather Mr. Tyson Bray is representing you.
That's correct, Your Honor.
All right, Mr. Bray, would you be able to start your video?
It shows started on my screen.
It's completely blank.
Tyson,
There we are. We got it. Now we can see you.
Excellent.
Thank you.
I just
All right.
stopped it and restarted it. So
Okay. All right. So it appears that Mr. Williams failed to appear in court on March 6th of 2024, and a bench warrant was issued for him. And what's the reason it should be set aside?
Yes, Your Honor. As the record reflects, that mail was returned, Your Honor. Mr. Williams had given the clerk or the jail his address, but the mail did not contain the apartment number. And so the mail was returned. He was not notified of the arraignment court date, Your Honor. In December of last year, he was working his job as a janitor at the airport through a subcontractor with Delta. They informed him of the bench warrant. At that point, he reached out to our office. And it's been a bit of a process. I've been busy with trial calendars, but I finally got down to the clerk's office, updated his address with the appropriate apartment number, and requested the set aside. And so that's why we're here today, Your Honor. I can also give some information about Mr. Williams. He is 67 years old, Judge. He currently lives in a senior citizen facility. That is where he resides. Your Honor, he's got a history of working. Again, he learned about the bench warrant because of his job at the airport, but he's actually been previously certified as a drug counselor. He did that for a good number of years. He's also been certified as a reverend. He's had a ministry. He did that for 15, 17 years, again, doing outreach, helping with drug addiction. And he also retired as a counselor, again, from, I think it was Atlanta Psychotherapy. So this is someone who's worked in the community. He's worked for a long time. He is now, however, on disability, largely due to congestive heart failure. So he's also got serious medical conditions that would make any stint in the jail particularly risky. So he's on a fixed income for a serious medical condition. So, Judge, at this point, he proactively reached out to me. He was not notified of the court date. We've corrected those issues. I've got good contact information for him. And so we are asking the court to lift the bench warrant in this case.
Ms. Falk, any comment?
Your Honor, it does look like, and that's, I'm trying to see the returned mail notice.
Right here on October 23rd. And it's missing the apartment number.
If that is the case, Your Honor, the state doesn't object to lifting the bench warrant. If it looks like, and I just wanted to see the address in particular on that notice.
It's 14 Meldon Avenue, and all it says, and it doesn't have looks like we've had a couple of returns already.
Right, and 14 Meldon Avenue is the address that was on the warrant with 417 on there. So it does appear that the apartment number was clearly stated on the warrant, was just not replicated on the notice. So we do not object to lifting the bench warrant.
All right, Mr. Bray, if you could submit an order setting aside the bench warrant. And
I will, Judge.
Would your client like to arraign the case today or reset it? Well, it'll have to be further notice. Well, he's already released, so it's just going to be further notice to trial.
Yes, Your Honor, that's correct.
Okay. Thank you. Mr. Williams, you're free to go. Mr. Bray, if you could submit the proposed order to Casey Strong.
Yes, Judge.
And as soon as that's put in there, the bench warrant will be removed from the GCIC.
Thank you so much, Your Honor.
All right, thank you. Ms. Vigiletti, just to go back down the calendar, so position 2 on Williams, the bench warrant is set aside.
Okay.
The Peggy Brown is pending, plea pending. On the probation revocation matter, position 1 is continued. Oh, that's time served, sorry. So position 2 is closed. Position 3, Flowers, is continued on probation. So position 4 is closed. As position 5, with regards to Floyd Jones, that probation violation matter is now closed. Position 6, she is continued on probation to report weekly. Position 7 and 8, probation revocation is reset to March 19th. This is a behavior reset. Position 9 is continued on probation. So position 10 is closed. Going to the add-on position, Zachary Alexis. That case, refresh my memory. I think it was reset to March 19th.
It was reset
To
for,
appear in person.
you said Thursday, Judge.
Yeah, Thursday. So sorry. So that's March
14.
14, excuse me. It's one of those days, guys. Okay. Mr. McLean, are you ready to address Peggy Brown?
Oh, sure.
Oh, let's turn this on just a little bit. Yes, Your Honor.
All right. And so we are ready to move forward with the plea. And so do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea, Your Honor.
All right. Ms. Brown, if you could unmute your phone device. And Ms. Strong or Ms. Grace, if you can rename iPhone to Peggy Brown. Ms. Brown, have you consumed
Judge.
any medicine or alcohol recently?
No.
And have you understood what's going on in your case so far?
Yes.
Are you satisfied with your legal services?
Yes.
Is anyone forcing you to take a plea today?
No.
And you understand that you're pleading guilty to battery, family violence. Would that be correct?
Yes.
And you understand that if you ever get arrested again for a same or similar offense, that would automatically be a felony arrest.
Yes.
All right. Are you still willing to move forward with this plea willingly and knowingly?
Yes.
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You won't be able to confront your accuser, challenge the evidence brought before you, present any defenses, arguments, and mitigating factors, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of battery, family violence?
Guilty.
Counts 2 and 3 will merge into count 1. Your sentence for battery, family violence is 12 months to serve 4 days, credit for time served, 2 days. You don't have additional jail time, but you will be placed on probation. You must report to probation next Tuesday, which will be March 19th, before 3 p.m. The report location is 132 Mitchell Street in downtown Atlanta. While you're reporting to probation, you will enroll in a domestic violence intervention program, and you must enroll in that program within 90 days of being released. You are to have no contact with Robert McCory. And what are we doing with the location, Mr. McLean?
Your Honor, I talked to her about that. She is the person who has the lease. She's always been the person who has the lease. He has lived there in the past, but he does not now.
Right.
He's never been on the lease. That's simply her place.
All right. She can continue to stay at 189 Mill Street in apartment 102 in Atlanta, Georgia, as long as Mr. McCrory does not live there.
And Your Honor, there's an issue too I need to ask the state about, and this is discretionary with the state in this plea bargain. She's under some strain in terms of her health problems. She's got dialysis going on. She'll be able to certainly schedule on the internet 1 hour a week to take the FBIP course. I am about to ask the court also for the financial break of FBIP is 5.5 months. So I'm going to ask the court to consider giving her a 6-month break on the probation fees because she is about to start a disability check. And her first one, I get the impression from talking to her that her first disability check hasn't even arrived. Mr. McCoy, I think his name is Richard McCoy, but I tried calling the number for him to ask whether or not it would be no further violent contact. Since I can't reach him, I would ask the state to consider whether the overall circumstances indicate whether they need to ask for no contact whatsoever. And if that is the case, she's willing to live with that. However, that will mean a little extra burden because he still helps her a little bit financially.
He cannot have any contact with her. She has to understand that.
Okay.
I'm going to waive probation fees up to and including the end of July. And then beginning August 1st, she needs to start paying her probation fees. And she will continue to report until the remainder of the 12 months are completed.
Very good.
All right. Any questions, Ms. Brown?
No, will the warrant be uplifted today?
Oh, and because of this plea, your bench warrant is set aside. Mr. McLean, if you could submit a proposed order setting aside the bench warrant on the
I will,
grounds that she's entered a plea.
Yes, Your Honor, I will do that.
All right.
Will I get a copy? I need a copy of that to give to my
Could
apartment.
you provide your email address to Mr. McLean?
I will.
Okay.
And also, does your telephone receive text photos?
Yes, sir.
Okay, I'll do it both ways. If you'll text me, you've got my phone number, so just text me your email and I'll get that to you both ways.
All right, thank you so much.
Thank you.
All right. Have a great day.
You too. Good to meet you.
Thank you. Same you.
All right. All right, so on Peggy Brown, that's going to be a set aside on the bench warrant and a plea instead. Okay, going back to the SAP calendar. Position, Miss Vigiletti there as well?
Yes, Judge.
Oh, okay, good, thank you. Position 1 is a null pros due to the plea taken in position 17. Position 2 was a plea. Position 3 is a null pros. Position 4 and 5, Kendall Brinson.
Mr. Brinson was released.
Okay. So position 4 and 5 are, well, was it released because of a purge amount being paid?
I don't believe so.
If you can confirm that, then that will close out the case. Otherwise, it's further notice for trial.
Oh, I see. Okay, I will have to find out.
Okay. Position 6, Collins was a plea. Position 7, Cresswell was a plea. 8, Cresswell, null pros. 9, Earl Crosby. Reset for global. So am I resetting it to next Tuesday?
Yes, Your Honor, the state is asking for a reset because there is a second case that we need to resolve.
Okay, reset March 19th. Position 11, that's for position 9 and 10. Position 11, John Davis was a plea. 12, Dawson was arraigned and further notice for trial. Position 13, Rodre Droulet. And that's going to be reset also for global recommendation. Is that 13 and 14?
That is correct, Your Honor.
13 and 14 are reset to March 19th. 15, Antonio Hammonds. And that is a waiver of arraignment and further notice for trial. So position 15 and 16 are further notice for trial. And Ms. Vigiletti, I think you've said you've attached the waiver of arraignment, right?
I did, yes.
Okay, thank you. 17, that was a plea. 18, had entered a plea in 2016. So these two cases have been null process for 18 and 19.
The state did submit the null pros orders, Your Honor.
Thank you. 20 and 21 was a waiver of arraignment and further notice for trial. 22 was a plea. 23 is a plea. 24 is a plea. 25 is a plea. 26, Brianna Marks is reset to March 19. That's a loan out to Gwinnett. 27 is reset to March 21st at 9 a.m. Position 28, Pulliam. I'm almost afraid to comment on these because I know I've got it mixed up.
Your Honor, I'm showing a waiver of arraignment, not guilty, reset jail jury as to all the cases.
There we go. Okay. 29 was a plea. 30, Riddle was released. 31, James Spann was a plea. 32, Spann is null pros. 33, Nephesia Stewart. Released or not released?
Released.
Okay. Further notice for trial. 34, Curina Stones is arraigned and further notice for trial. 35, Antonio Tucker was a plea. 36, Anthony Townsend was a plea. 37 was a null pros. 39, Walding. That one is reset to March 19th SAP calendar. 30, position 40 and 41, Walding were pleas. 42, Walker was a plea. 43, Walker is null cross. 44, Woodard is
I show a negotiated plea as to both
Yeah.
cases, Your Honor.
and then 45 is a null cross because of the plea. And you're right, 44 is a plea for 2 cases. 46, David Wright is a waiver of arraignment and further notice for trial. And same announcement for 47, further notice for trial.
With an
I
amended
addressed all
bond,
the
correct?
cases? Ms. Strong?
With the amended bond for Mr. Wright, correct?
Correct, yeah.
And who is Ms. Vigilante? Could you please send me that bond over so I can get it?
I
signed with
think
the
it
rest
was
of my-
Mr. McLean. Was it Ms. Vigilante or Mr.
That
McLean?
was my case. I'll send it to you this afternoon, Ms. Strong.
Okay.
Thank you.
All
Ms.
right, well,
Strong, sorry, Your Honor. Ms.
That's
Strong,
right.
do you have all of my null pros orders?
I received several. I believe you sent all of them. I think I'm-
Okay, if I'm missing any, please don't hesitate to reach out to me.
Sure, thank you.
Thank you.
all right, everybody, you are free to go. For those of you coming back at 2 o'clock, make full use of this 15-minute break. All right, thank you, guys. Take care.
Thank you. Thank you.
Bye-bye.